so that
Okay,
we
great, great,
can be
great.
double sure that things will come out okay. All right, so as I was saying, folks, we're going to spend about half of our time on prepping for the written exam portion, and then we'll probably in the middle take about a 10 or 15-minute break, and then we'll go into the second half, which is preparation for the written samples and the oral exam. And you will be able to get, correct me if I'm wrong, Norman, but you will be able to get CEUs if you want them from that work for the National Board of Certified Counselors. If you're interested in
Yeah,
that, though.
NBFE. Yeah, NBFE is a provider for NBCC,
Mhm.
and NBFE will provide the actual CEUs and before contact hours or point 0.4 CEUs. Just for your information, Aaron, I see that Howard Carroll is actually in attendance.
All
He
right.
is actually the chair for the oral examination committee, so he's going to be an incredible, great help because he's the one that says nay or yay.
Wonderful. So we'll
So,
be we'll be hoping
so
that he'll chime in on some stuff then today as we go through here. So we also, at the end of today's webinar, you're going to see on your screen, you should automatically have a survey that will pop up. And the survey will be labeled Webinar Evaluation and CEU Request Form, I think. And it has a series of questions. I think there are about 12 questions that it asks you. And you will need to complete that to get any kind of verification for attending today's training. What will happen is we'll send out certificates to everybody who completes that evaluation form, and that will also make you then eligible for the CEUs. So please make sure you complete that at the end of the webinar. Now let's say that for some reason something goes wrong and you can't complete it at the end. Maybe you're on a time crunch or maybe it disappears from your screen. The good news is that tomorrow you should be receiving an email that basically thanks you for attending, and it will have a link on it that allows you to complete the survey in the event that you haven't already completed it. You don't want to complete it twice, but if you haven't already completed it when you get that email, make sure you complete it then. My preference would be that you complete those evaluation forms within the next 48 hours so that we can make up all the certificates at once and get them done and out of the way. That would be preferred. Okay, so I'm going to start off by kind of telling, oops, I somehow jumped way ahead on my presentation. Let me get back to where I mean to be at. Okay, I want to start off by just taking a little bit of a pulse of who we have on the webinar today. I'm going to launch a few polls, and basically the way that a poll works is that suddenly your screen will show a question. In fact, I'm going to do it right now. And you should be seeing right now on your screen a question. And that question is asking about your professional identity. I'm trying to get a sense of whether we mostly have counselors that are on the webinar today, or do we have social workers or psychologists. So go ahead and click the button that you most identify with as quickly as you can. Looks like so far we've got 70% of you who have entered something. And now we're up to 80%, so maybe there's one or two of you still out there that hasn't answered yet.
it hasn't allowed me to answer probably as an organizer.
Oh, okay. Well, 90% of you have voted on it, so I'm going to launch the results here in just a second. And so as you can see, everybody is saying that they're a professional counselor or a mental health counselor. So that's our audience today. We don't have any MFTs, LCSWs, psychologists, so forth.
Actually, we do. I'm also licensed marriage and family.
Oh, okay, yeah, we probably have some folks who might be duly licensed, huh?
Dual, yeah.
All right, cool. So now I'm going to move on to, let me hide those results, and I'm going to give a second polling question here that will help me get a sense of who we have and what your background is. I'd love to hear what kind of experience you've had in the forensic mental health arena so far. So what I've done is I've launched a poll that asks you to click on all that apply. Have you done competency evaluations yet? Have you done personal injury or disability or workers' comp evaluations? Have you done child custody or parenting evals? And have you done clinical evaluations that are used in forensic settings, like say a substance abuse evaluation or a mental health evaluation that's focused on, here in Florida, we call it a downward departure. I'll get to that later. Or a potential for violence or aggression, maybe a domestic violence related evaluation or something along those lines. So it looks like so far 80% of you have answered that question. Give you just a moment longer if there's one or two of you still working on it. All right. And so with 90% of you having voted, I'm going to go ahead and launch our results here. Oops, I just clicked on the wrong button. Let me go back. All right, so it looks like everybody who answered said that they have experience with clinical evaluations that are used for forensic purposes. And the second most popular, 67% of you say in potential for violence or aggression. Third would be child custody and parenting. And only about 22% of you have done competency evals. No one's done a personal injury, disability, or workers' comp evaluation yet, it looks like. All right, so that's what we have in the room. Cool. And then a third and final question that I'm curious about before we even get going here to kind of take a pulse of who we have in the room is I'm just curious about what you are most anxious about, assuming that you have some kind of anxiety about the CFMHE process. Are you more anxious about the written exam, the sample reports, or the oral exam? That's what I'm curious about. So I'll give you guys a moment to think about that and answer it. Which one maybe is the most intimidating or you have the least comfort with? I'd love to know about that. All right, so with 90% of you having voted, I'm going to go ahead and close that poll and launch our results here. Looks like we have a pretty split answer here between the written exam and oral exam. About half of you are, with one person probably being most anxious about the sample reports. One or two people actually, it looks like. So, all right, so that's a pretty good split group here. Okay, so I'm going to get back to the presentation here, and I'm going to start off by just giving you a little bit of information about me and who I am. Sorry, I forgot to turn my cell phone off here, and let you know what some of my limitations are as far as being able to answer some of your questions, and then some of the areas that I might be a little bit more help with. Fortunately, we have some people with good experience on today, so maybe some of you can chime in where I can't. But my experience really with the forensic arena has been pretty exclusively doing more in-depth clinical evaluations, primarily substance abuse evaluations. I get a lot of referrals to do substance abuse evaluations and answer questions for the court about that. But the second most common evaluation that I do is I get a lot of requests from defense attorneys to do mental health evaluations that they are intending to use as a strategy to examine whether or not their client could be eligible for downward departure sentencing. Now, one question I forgot to ask, how many of you are working here in Florida? Maybe if you could unmute yourself and just let me know what state you work in. I'd love to hear what we have in the room as far as that goes. I forgot to create.
Texas.
Texas, all right.
Florida.
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 All right.
Texas.
Yeah.
New Hampshire.
New Hampshire,
Ohio.
Texas, Florida, Ohio. Okay. So we have a good split group here. We got several states that are represented. That's nice. Well, I'm in Florida, and I don't know if you have this in some of the other states, but here in Florida we have a provision that that sometimes people can get. I don't know if the right word is more lenient, but kind of more lenient sentencing if they have a mental disorder that warrants treatment. And sometimes a defense attorney will try to get some kind of mandated treatment in lieu of more of a punitive approach for sentencing. Do you guys have that in some of the other states? I'm not hearing any answers, so maybe not. Okay. So
my guess is that probably a lot of the candidates and probably aren't even aware of that kind of a process yet because
okay.
they haven't had the experience with it.
Good thing to find out about. That's really the bulk of my forensic evaluation experience. I've done a lot of training in competency evaluations, but I've done zero actual competency evaluations, in part because I'm kind of holding off till I get done working on my doctorate before I start expanding into doing that kind of work. So I'm just continuing to train in it. So So the folks who are on who do maybe child custody cases or do some competency evaluations, feel free to chime in when we get to those sections if you have any information that you think would
Sarah?
be helpful to share. Yes.
My screen is still showing the poll results.
Oh, okay. So I never took
My,
that down.
yeah.
All right, let me do that. You're right. I show here that I never took down the poll. So thank you
Thank
for letting
you.
me know about that. Hopefully, you all should now be seeing um, the screen and see about the presenter on your screen. Okay.
Yes.
All right, perfect. We're back on board then. Great. Okay, so let's get into it. The written exam is a computerized exam. You'll be on a computer and you will, the system sort of randomly generates questions from a pool of questions. You'll have 100 multiple choice questions and they'll be in 20 different domains. And these are those 20 domains: assessment, child abuse, child custody examination, competency, definitions and terminology, and you have a glossary in your study guide. On that note, by the way, one thing I want to make clear, hopefully you all have your oral and written exam study guides. If you don't, if you look at your GoToWebinar panel, that rectangular panel, then you will see a space that says handouts. And it says probably 5 of 5. So if you click on and expand that screen, you can download handouts. The handouts that I have are PDF versions of the two slideshows that I'm going to be giving today. And then I also have the oral exam study guide and the written exam study guide and the credentialing manual from MBFE. So the stuff that we're going to review today is not intended to be a replacement for using those study guides. Those really are your primary resources to use. It's more like a supplement to those study guides to really help you to prep. So the other domains are ethics, expert witness, landmark cases, malingering, parental alienation syndrome, personal injury, psychometry, sexual abuse, involuntary commitment, interviewing techniques, the written report, statistics, and then juvenile justice. Those are your 20 domains that the test is designed to tap into and see if you have a pretty good understanding of those areas.
Excuse me, Erin, I apologize, but I can't find how to download the slides. Can you just say that one more
Sure
time?
thing. Yes, the rectangle, you should have a panel, and at the bottom of that panel, it should say GoToWebinar. And that rectangular panel gives you all these different headings that have plus or minus symbols on the left-hand side of them, like audience, view, screen sharing, webcam, audio, dashboard, that sort of thing, I think. There should be one that says handouts.
No, I don't seem to have that.
Oh, okay. You don't see, does anybody else having a problem seeing the handout part on the control panel?
I have it under the questions.
You have it
There's
under questions?
handouts 5 under questions.
Okay.
I don't even have questions.
Well, I can't see it right now, but I did see it earlier.
Yeah, I had that line earlier as well, but now it's gone.
Yeah.
Okay. Interesting. So somehow it disappeared. Well, you know, at the very least,
Re-click the red arrow at the top. Clicking that red white arrow at the top should bring it back out.
Okay, yeah. If you ever click on that red arrow, what that does is that red arrow gets rid of all that stuff that I'm talking about. And then to get it back, you have to re-click on that arrow.
Oh, yeah, I do see it now.
Okay.
Okay, I haven't got, oh, what happened? Oh, you went away.
All right. Man, technology, it's great.
Oh.
It's great sometimes, but it's a little complex too, the system. Is everybody able to get to the handouts now? Kind of figured it out?
Yeah. Yes.
I hear you, but I've lost all visual here, sorry.
Ah, okay. Hopefully that'll change in a moment. It could be that you have a slow internet connection maybe, or your computer's really busy right now. So hopefully that screen will come back and we'll get you going.
Okay, so what came back is the red arrow again?
Yes.
Oh, there you are. You're right. Wow, am I slow? Okay. So
All right.
just so I can understand, we need to print these off now, or we can do it later?
I think you can download them at any point during the presentation today. So you might want to go ahead and download them now if you don't have those resources. That way you won't have to worry about it, because I think that once the webinar is over, you won't be able to download them. But what I can do to be on the safe side is I can send out a follow-up email to all of you where I just include all those attachments in case you weren't able to access them today. So no worries,
Okay.
we'll figure out a way to get you all this information.
That would be wonderful. Thank you.
Sure, no problem. All right, so those are the 20 domains. Now I'm just going to start off with a little bit of general information about forensic mental health evaluations. Now, all of you, it sounds like, are counselors, and some of you might also be marriage and family therapists, but it looks like everybody's a counselor who's on the line today. So here I have the American Counseling Association in their Code of Ethics, the newly revised code in 2014. They provide a definition for forensic evaluation, which is pretty broad. The process of forming professional opinions for courts or other legal proceedings based on professional knowledge or expertise and supported by appropriate data. The MBFE pretty much considers any evaluation that's being used for purposes of the court to be a forensic evaluation. And I know that there's some other people who say, well, if it's a more clinical evaluation, if the question is clinical in nature, then it doesn't matter whether it's being used for the court or not. It's not a true forensic eval. But that's not the MBFE's position from the way I understand it, nor does it look like it's the American Counseling Association's position when you look at the way they define a forensic evaluation. So what's different between a forensic mental health assessment or evaluation and your traditional therapeutic or clinical assessment? Some of the differences are scope. Usually forensic evaluations are more narrow in scope. You're typically answering very specific questions posed by the court or by some other legal entity. Now, a good example would be, I'm going to show you today a sample report from a case where I was given some particular questions, some very specific questions, but as you can see from those questions, the court's asking me to do a very broad evaluation because their questions were, number one, does the individual have a diagnosable mental health disorder, one or more diagnosable mental health or substance use disorders? And then number two, what if any treatment is being recommended? So even in that case where an evaluation looks very much like a typical clinical evaluation in some respects, they're still asking very specific questions. So the scope is usually more narrow with a forensic evaluation. You might have a question about competency. So then the second difference is the importance of the client's perspective. In a therapeutic or clinical assessment, I'm going to put a lot more weight in the client's perspective than I will in a forensic evaluation. Because in a forensic evaluation, the way I like to think of it is that my client is the truth, it's objectivity. And rather than the world as the client sees it being what I'm most interested in. I'm certainly interested in that in forensic evaluation, but I'm not going to put as much weight in it because I'm looking for objectivity from an outsider's perspective. Voluntariness, of course, is a big difference. Most folks who come into my practice is about 75% treatment and probably about 25% evaluation, if I had to just sort of guess off the top of my head. So most of the people who are coming in for treatment are coming in just because they want to. They're usually very highly motivated to come in and do some work. But people who come in for forensic evaluations are typically under some pressure from some other outside party, or maybe even coerced to some degree to coming in. So the level of voluntariness is obviously going to be different. And the ethical principle of autonomy is emphasized more with the therapeutic assessment than it is with a forensic evaluation. There are more threats to validity when it comes to forensic evaluations because there are a lot of ulterior motives. And the relationship and dynamics between the evaluator and the client are going to be very different. Now, Dr. Hoffman, I know, had recommended when I first started doing training with the MBFE that he mentioned, Norm, that you like to consider your clients who are there for therapy to be patients, and then you call your clients who are coming for forensic evaluation clients. And that's one way that you've kept that distinct difference in your interaction is to even have different words for those two scenarios. Is that right?
That's correct.
Yeah, I took your recommendation on that. I started doing the same thing for myself and my practice. So even in my notes and things, the folks I do therapy with are patients, and then the folks who are coming in for forensic evaluation are clients. Because my relationship's going to be very different. And of course, a big part of the consent process for forensic evaluation is explaining to clients that this is not therapy and that you're not their counselor. What the importance and the relevance of that dynamic is and how it's different. So finally, pace and setting is going to be a big difference. See, when people come in for therapy, I do my initial assessment, and it's sort of a hypothesis. It's a diagnostic impression or provisional diagnosis. And then as I continue to work providing therapy with the client, of course, my way of conceptualizing the case can be adjusted over time. And even my diagnostic impression may shift as I continue to work with the client over sometimes an extensive period of time. But you won't necessarily have that luxury when it comes to forensic evaluation. You may have a very limited amount of time with the client. You oftentimes might be going into a jail or some other setting to perform the evaluation. So you're going to have some time restrictions and limitations and so forth. Of course, that being said, I spend hours and hours on forensic evaluations, and I don't do that with people who come in for therapeutic or clinical evaluations.
Hello?
All right, so you guys got any questions so far on just what we've covered up to this point?
Okay, here's Val. I got you off.
All right.
Yeah, sure.
Not hearing anything from anybody except for Norm's phone call in the background? All right, so ethical considerations, just a quick review of a few things here. The ACA, I put the ACA Code of Ethics on here as well as the American Mental Health Counselors Association, or AMCA. Both talk about counselors having to abide by state and federal law. Both emphasize objectivity when it comes to forensic evaluations and differences in consent between therapeutic and forensic evaluations. And both also emphasize that you don't provide an opinion.
Aaron, I hate to interrupt, but there's someone trying to get in. I can't see how to invite her. I have the email address.
Okay.
She said she can hear us, but she can't see anything.
Oh, okay.
Is there any way? I don't see the invite button.
Can I ask first, is she logged in on a computer, a tablet, or a smartphone?
I don't know that.
Okay. If she's able to hear us, is she hearing us through the phone or is she hearing us through a device of some kind?
I don't know that either.
Okay. So I'm kind of curious. I'm wondering if she might be using the phone for audio but unable to log in through her computer or something.
Okay, I'll ask her that. You can just continue. Go ahead.
Yeah, I would suggest trying to send her the links that I sent you. Maybe she could back out if she is on a computer or tablet and then try to log back in. A lot of times that'll fix the problem.
Okay.
Okay, so both the ACA and AMCA prohibit counselors from providing forensic evaluations for clients who have been therapy clients. So if you ever did therapy with a client, you cannot down the road do forensic evaluation with them. And the opposite is true as well. If you see a client for forensic evaluation, you can't then provide therapy for them. That's strictly prohibited. And that kind of thing will get you into trouble too if you ever end up maybe being cross-examined or something, and the opposing counsel finds out that's the case. It gives the appearance, at least, of not being able to be objective. The truth is, you might not be able to be objective if you're doing a forensic evaluation for somebody you've also done therapeutic work with. So you cannot do both. And I didn't know this actually when I originally started my training with MBFE, so this was helpful information for me to find out. Also, our Code of Ethics requires that we not go into court and provide opinions on cases for folks that we haven't even evaluated or seen. I know, Norm, you have a story about a really established expert who maybe got disqualified because she came in and she was providing opinions on a case and she'd never even met with the client before. So that's
this was a high-end, very high-end $10,000 evaluation plus expenses to come here from Fort Lauderdale, and there was a lot of bias in the evaluation. I won't go into that, but he did make a diagnosis on a female partner of his client that he never witnessed, and he called her a borderline personality disorder. And when I went to court, I mentioned about the ethical violation. He became disqualified. His client became so disgruntled that I think he filed a complaint because he lost about $20,000. And one word, one statement in the report disqualified him. One error.
That's something. All right. So bottom line is, of course, you need to meet with the client before you start providing opinions. And I'm going to get more into some of that stuff later on, too. So some of the types of forensic mental health evaluation, we have competency evaluations, and that can include competency to proceed. I mean, does the person have the capacity to really participate in their own defense? Do they understand the proceedings and the trial and nature of the charges against them and so forth? There's a typo here. It should be to waive certain rights. And then a second type of evaluation is criminal responsibility. What was their mental state at the time of the offense? Were they able to distinguish between right and wrong and those sorts of things? I have no interest in doing those kinds of evaluations, at least not at this point, and I think they'd be pretty tricky to do in a lot of ways. Civil commitment proceedings, child abuse and neglect, child custody or parenting, personal injury evaluations, substance abuse, domestic violence, potential for violence, and then I told you guys earlier about here in Florida, downward departure. You may very well have statutes like that in your states for those of you who are in Texas or New Hampshire or Ohio that are on today as well. So these are some of the kinds of evaluations you may find yourselves doing. So now let's get to actually this is really what we're about to get into mostly here is some landmark cases. Now all of the landmark cases that I'm about to show you are cases that are contained in your study guide. And what I've tried to do is I've tried to at least provide just the bottom line, what was the most important aspect of the landmark case, with the hope that, if you know these sort of bottom line important facts about each case, or you have a pretty good understanding of them, then when it comes to the written exam, hopefully you should be able to answer questions accurately about any of these cases. But as we go through a few of these, I'll try to give you a little bit more background as well. The first case is Addington versus Texas. This was a decision issued by the Supreme Court of the United States. So anytime you'll see SCOTUS here, of course, that's what we're talking about. And the most important aspect of the case is that it raised the burden of proof for involuntary commitment from preponderance of evidence to clear and convincing evidence. Now, any of you know what is the difference between those two phrases, preponderance of evidence versus convincing evidence? Nobody wants to take me up on that? Which one do you think is a heavier burden of proof?
Clear and convincing evidence?
Yes, it is. You're right.
Convincing.
Concrete evidence?
Mm-hmm. Yeah, preponderance of evidence is the more lenient of the two burdens of proof, and it basically means more likely than not, given the facts available. Or you could loosely interpret that as being, 51% probability or higher, although you'll never want to use that number in court. It just opens you up to too many other questions. But a preponderance of evidence is more likely than not. This is the burden of proof that a lot of times is used in civil cases and those sorts of things. You're not going to see this being the burden of proof in criminal cases. But then we move up to clear and convincing evidence. And here we're a notch higher when it comes to how convincing the case has to be. And so clear and convincing evidence, I don't know if, I want to say if you had to think of a number in your head, probably something around 75% probable or something. Although again, you don't want to use these numbers if you're ever asked what these terms mean in court. What do you think about that one, Norm? How would you define clear and convincing evidence? No, not on right now. Okay, we'll move on now real quick. I do see somebody has asked a question. Oh, here we go. Somebody has said 51% is preponderance of evidence. So there we go. You're right
I was
about that.
muted, Aaron. I was talking. I forgot I was muted.
Oh, okay. You were pontificating and no one was there to listen. Okay.
Yeah.
So do you have
But
any
again,
extra
you're absolutely
feedback
right.
on that question?
I was agreeing with you that we don't use the numbers. We use preponderance is what we use in family court exclusively. You don't have to have clear convincing, which is, as you said very artfully, 75%. It's usually we see that in civil lawsuits, the lawsuits that anybody who's sued will use that kind of loosely argumentative kind of standard.
Yeah. Okay. Now, I'll tell you, if you're interested in a little bit of the background of this case, basically Addington's mother had petitioned for him to be involuntarily committed prior to him being arrested for a minor misdemeanor charge. And the jury was instructed to use clear, unequivocal, and convincing evidence as the standard for determining whether or not he should be involuntarily committed. And they found him to be mentally ill and in need of hospitalization for his and others' welfare. He appealed successfully to the appellate courts, but then the Texas Supreme Court ruled against him. So then he appealed to the U.S. Supreme Court, which overturned Texas's decision. And their argument, as many of the cases that we'll be looking at that are federal cases, the argument was that his 14th Amendment rights to due process were violated. And they essentially raised the burden of proof from preponderance of evidence to clear and convincing evidence, but they didn't raise it to the point of beyond a reasonable doubt. So beyond a reasonable doubt is the highest of those three burdens of proof. Beyond a reasonable doubt isn't quite 100%, like we're 100% certain, but it's awfully high. It's so certain that you would be willing to act on a particular conclusion as though it were a fact. So clear and convincing evidence beyond a reasonable doubt is the highest burden of proof used in the court. So the reason they didn't raise it that high is that they recognized that there is some subjectivity involved in the diagnostic process when it comes to forensic mental health evaluations. So they thought it was reasonable to have sort of a middle ground, not preponderance of evidence, and not beyond reasonable doubt, but clear and convincing evidence, the appropriate standard. Okay, so then we move on to Colorado versus Kennelly here, another Supreme Court case. The background behind this case is that Kennelly approached a police officer and he confessed to murder. So he just walks up to a cop and says, "Hey, I killed someone." And the argument was that during that period of time that he approached this officer, he was acutely psychotic because of a diagnosis of schizophrenia. And the officer did the right thing in reading him his Miranda rights and explaining his rights to him, and he chose to waive his right to counsel and went forward with his confession. And then he appealed after being convicted, saying, "Look, I wasn't able to really waive my rights because I was acutely psychotic." Specifically, he argued that at the time, he believed that God was telling him that he had to either confess to a murder or commit suicide. And not wanting to commit suicide, he falsely confessed to a murder. So then the ruling originally, I think, let me see here, he was first convicted, then the Colorado Supreme Court reversed the decision, but then it went up to the Supreme Court of the US, which reversed Colorado's decision, and they did it because of a very specific line in the Miranda versus Arizona case, which we'll get to in a moment. And in that line, the line basically specifies that confessions may only be thrown out if the confession was solicited after being coercively interrogated by the government. And so because the police officer didn't coercively interrogate Kennelly, they couldn't toss it out, even though he may have very well been acutely psychotic at the moment. So the next case, Daubert versus Merrill Dow Pharmaceuticals. The background with this case is that we have two guys, Daubert and Schuler. They and their parents sued Merrill Dow. And the reason they sued is because they were arguing that a medication or a drug, Bendectin, caused them to be born with birth defects. And this case was pretty important because it really helped to highlight the sort of Daubert versus Frye standard. Basically, the court decided that the methodologies that the plaintiffs in this case used were not widely recognized or accepted yet. They weren't validated objective tools in the scientific arena. And so the case basically said, look, recently we passed the federal rules of evidence, and those rules take precedence over the previous Frye standard, which essentially is now outdated in terms of federal cases. So we're going to talk a little bit more about the difference between Daubert and Frye in a moment, but this case obviously is a big part of that difference. All right, so let's move on here. Descheny versus Winnebago County. This was, again, another Supreme Court case, U.S. Supreme Court case. Basically, it's a pretty sad case. We have a child, Joshua Descheny, who was removed from his home, and he was removed because there were child abuse allegations against his father. He was then returned to the home based on recommendations of several professionals, including psychiatrists and psychologists and so forth. And then there was a social worker who was providing follow-up with the family, and I think over about a year's period or so, the social worker kept reporting signs of suspected ongoing abuse. The social worker thought that the father might be continuously abusing the child, and yet nothing was done. The child wasn't removed from the home or anything. Child eventually ended up in the hospital in a life-threatening coma. And they discovered during an emergency surgical procedure very strong evidence that the child had had ongoing trauma over an extended period of time by impact with the child's head. So more evidence of ongoing abuse. So fortunately, the child did not die, but the child did end up with some permanent brain damage. And so Descheny's mother then sued social services and argued that by failing to protect Joshua, the government violated his due process rights under the 14th Amendment. So here we keep coming back to the 14th Amendment, which was enacted, I think, during or right after the Civil War. And one of the things that the 14th Amendment really says is, hey, the government cannot deprive people of their liberty without due process. And so the court basically said that she did not have a case. And the reason she didn't have a case is that the court didn't violate, or the government didn't violate Joshua's due process. His father did. His father was the one causing the damage or the harm, not the government. That's really the reasoning that they used for this case. All right, so let me go back here because I skipped a case to take a look at, which was Dillon versus Legg. So the Dillon versus Legg case, the background is that a mother and a daughter witnessed a second daughter's death related to a motor vehicle accident in which the other driver was determined to be negligent. The California Supreme Court established the tort of negative infliction of emotional distress in this case. Basically, they sort of clarified some of the factors or establish some factors that have to be considered when somebody's trying to sue for maybe traumatic distress connected to witnessing an atrocity of some kind. And three factors that they explored: whether the plaintiff was near the scene of the accident, whether the plaintiff suffered an emotional shock from observing the accident, and whether the plaintiff was closely related to the victim. Those are all three factors that they established that must be considered in those cases. The Dusky case is a really important case. This is another Supreme Court ruling. Did I skip? I think I did skip something. Let me go. No, I didn't. Okay. Yeah, so the Dusky case, I'm going to get my panel out of the way here for a moment because I can't even see the screen here. The Supreme Court affirmed a defendant's right to a competency evaluation before proceeding to trial and established that a defendant must have sufficient pressability. Basically, what this court did was it really established the standards for competency. It helped to not only define how do we know whether somebody's competent to proceed or not, but also it established that a defendant has a right to an evaluation of competency if they raise the issue of competency. So those standards of competency that were a part of that decision are standards that you really need to be familiar with if you're going to be doing competency evaluations, obviously. Okay, so on to the Durham case here. Let me see, I think I had a couple notes about the background on that I wanted to, no I don't I guess, okay. So this was the DC District Court of Appeals overturned Durham's conviction, reasoning that accused is not criminally responsible if his unlawful act was a product of mental disease or defect. Okay, this ruling has basically been overturned and superseded, so it's no longer in effect. This ruling, they made an argument that was much more lenient, made it a lot easier for people to be determined incompetent. Or I'm sorry, to be determined to not have criminal responsibility if they had a mental illness. All right, so let's move on here. Fair versus Michael. What this case basically said, we had there was a juvenile who was in custody. The law enforcement was questioning the juvenile, and the juvenile asked to speak to his probation officer. Law enforcement officers denied his request, and then he appealed, saying that, you know, by not allowing him to speak to his probation officer, his Fifth Amendment rights have been violated. But, you know, this case clarified that a probation officer is not an attorney, and so Fifth Amendment rights were not really violated. Now we get into the Fry case in 1923. Now, do any of you know, those of you who are in Texas, I think Ohio and New Hampshire, anybody outside of Florida, do you know if your state uses the Fry or the Daubert standard when it comes to requirements for expert testimony? Anybody want to chime in on that? I do see there are a few people here. Yes.
Yeah. So I actually am from New Hampshire but work in Vermont, and I believe they use I'm not sure I get it right, the Durham, what was the question again? Which one?
Yes, in your state.
The criteria is whether the person can participate in it with their lawyer in their defense.
Okay, let me clarify. We're not talking about the standards for competency to proceed here. What we are talking about is Daubert versus Fry standard. And so those standards deal with what makes somebody an expert witness and what makes them qualified to be an expert. And so you may not know, but those of you who aren't in Florida, do you know if your state uses Daubert, the Daubert test or the Fry test as their standard for expert witnesses? In Florida here, we use Daubert. We transitioned from Fry to Daubert in July 2013. All right, I'm not hearing anything so you guys probably don't know in your states. It might be a little clearer too when we really go over Daubert versus Fry in a moment here. But, well, actually, you know, let me do this.
Can you tell us, excuse me, can you tell us how to find out?
That's a good question. You know, the easiest way to find out probably will be just to Google. Actually, Wikipedia talks about Daubert standards versus Fry standards, and it lists which states use which standard in a Wikipedia article. So that's probably your easiest and quickest way. I know, of course, Wikipedia can have errors, but generally speaking, it seems to be pretty accurate these days. You could probably also Google your state and then Google Daubert versus Fry. A lot of attorneys in each state have on their websites FAQs that talk about which standard is used in their state of practice. So that's another way you could probably easily find out. I Googled just the other day, I think Daubert versus Fry, and I saw a bunch of articles from attorneys on their websites where they really go into pretty good detail, and they tell you in their state which standard is being used.
Hey, gang, could you please mute yourselves until you're asking a question because we're getting background noise?
Yeah, I should clarify. I saw that there were a few people that jumped in to the training since I originally unmuted people, so I went and unmuted them. And so let me just remind you, although I have unmuted everybody, until you're ready to actually talk, I would like you to mute yourself. And the way to do that, if you came in late, you should see a rectangular GoToWebinar panel on your page. And you should see some icons, including an icon that looks like a microphone, one that looks like a video camera, and then the one that looks like a microphone, if it's green, you'll want to click on it until it turns gray. And then that'll mute you. And if you want to be unmuted, you just click on it again and it'll turn green. All right, so let's see, where are we at here? Oh, actually, I have the answer to your question right here on the slide. Looks like FRI is still being used in California, Illinois, Maryland, Minnesota, New Jersey, New York, Pennsylvania, and Washington, which is nobody on this webinar. I think all of you are probably in Daubert states. Okay, so HUDA versus Board of Medicine. Now this case originally confused me until I looked at a really particularly important fact about this case. The background is that we had a physician, HUDA, who sued the hospital that he was working at. And in the process of his lawsuit against the hospital, he released patient records without informed consent as a part of the proceeding. He released confidential information, in other words, in the course of his case against his employer. That patient was not a party in the litigation, the patient whose information was disclosed. So the Board of Medicine somehow found out about this and they took disciplinary action against the physician. He countered their disciplinary action and he argued that, look, I had judicial immunity because this was a proceeding, a legal proceeding, so I should have been allowed to bring this information up. But the court actually sided with the board and said that you can't use judicial immunity as an argument to disclose patient records when the patient is not a part of the lawsuit and when there's been no informed consent. So that's something important to pay attention to because a lot of times you will feel pressure from legal entities to disclose confidential information. Understand that if you still disclose that information, you could get into trouble for it. Even though people might be telling you that you have immunity or whatever else. Why I was originally confused with that case is that originally I assumed that the patient was suing the physician. I didn't realize that the physician was suing his employer. So that's why I was really confused about this initially. I was like, what? So you can't defend yourself by providing any information about that case? And that's not what was going on.
A point of information that I learned many years ago is to become immune judicially is to get appointed by the court rather than ordered by the court. It's a moot, it's a little known factor, but it's important to make sure you tell your attorneys to put appointment because they're the ones who write up the orders.
Okay, well there you go. All right, so the next case we'll look at is Jablonski versus U.S. This is the Ninth Circuit Court of Appeals, and they determined that a mental health professional's duty to predict dangerousness includes consulting a patient's prior records. The scenario, the background with this case, if I remember right, is that there was a gentleman who, his wife's mother, I think, so his mother-in-law, I think, and maybe his wife or maybe girlfriend, they were petitioning for him to be involuntarily committed because he had threatened to harm them or something, and they thought he was in a compromised mental state. But he actually voluntarily consented to be evaluated. So he went to a psychiatric hospital or psychiatric unit to be evaluated, and a psychiatrist evaluated him and determined that he wasn't a threat, but the psychiatrist never actually looked at his prior records and really didn't do much of anything other than talking to him and asking questions. And if he looked into the records, he would have seen some evidence of a very aggressive or violent background. Well, he ended up getting out and killing the wife or girlfriend, if I remember correctly. So that was obviously a huge case, and it deals a lot with liability when conducting those evaluations. I see, looks like Ben Warner sent us a comment, and he said that Texas is a Daubert state, so that's good clarification there. And then he provided a website on, I don't know what that website is, actually. It looks like it's drtomoconnor.com. If you have more that you want to say about that, what that website has been, then let us know. Maybe it's your reference about Texas being a Daubert state. Virginia Noy is asking the question, can Dr. Hoffman repeat his comments on how to be assured judicial immunity? Norm, do you want to answer that question? Unmute yourself first because we can't hear you.
Yes, I just unmuted. I always forget to unmute. I start talking. It's not to assure. It's the idea is you have to train your attorneys who are asking you to come in, inviting you as a person to become an expert. You want to ask them to ensure that they have you an appointment by the court rather than court ordered. Court order puts you in a different light if you're ever going to get sued, then you probably won't. You can always get sued, but there's less likelihood that you'll be vulnerable if it's an appointment.
All right. Thank you for clarifying. Okay, so Jackson versus Indiana. This was a really important case. It's often cited as a case that it's a big part of a series of decisions in the 70s that clarified the rights of people with mental illness. The Supreme Court of the U.S. determined that Indiana violated due process. So again, as so many of these cases, we're looking at the 14th Amendment, by involuntarily committing Jackson for an indefinite period of time solely on the basis of his permanent incompetency to stand trial on the charges filed against him. Background is that Jackson was both, let's see here, he was deaf and he was mute, if I remember correctly, and had a really low IQ. And it was determined that he was incompetent to proceed and that it was unlikely that he would ever be able to be competent to proceed. And so they just kind of warehoused him, and we're going to indefinitely warehouse him for what I think might have even been originally a relatively minor charge. And so the Supreme Court ruled you just can't indefinitely confine somebody just because they're incompetent to proceed, and there need to be some restrictions, limitations on that. What they didn't do a very good job of in this case is being very specific about what was reasonable in terms of how long to be confining somebody, but there were some later cases that helped to clarify some of those things. Okay, so Jaffe versus Redmond. Supreme Court of the U.S. created a psychotherapist patient privilege in the federal rules of evidence. I didn't even look up any information about this. Anybody know anything else about this case that they want to share? Nope. All right. Well, let's move on to Kent versus U.S., another Supreme Court, U.S. Supreme Court case. A juvenile must be afforded due process rights, specifically that a waiver of jurisdiction from a juvenile court to a district court must be voluntary and knowing. So just help to clarify the due process rights of juveniles. I don't know if this is pronounced Lipari versus Sears Roebuck, maybe, but Federal District Court in Nebraska allowed the plaintiffs to proceed in a lawsuit against a hospital because it was for the jury to decide whether the therapist knew or should have known of the patient's dangerous propensity, rejecting the Tarasoff limitation to an identified victim. So what this case helped to, I think I had some other background information I wanted to give you guys about it, but I can't find it here. Let me see if I can remember off the top of my head. Okay. So here we looked at, like, for example, here in Florida, we have a Baker Act procedure. You probably have something similar in your states, and it's a procedure for if you determine that somebody is an imminent risk to themselves or others because of a mental illness. So in that scenario, we as licensed clinicians here in Florida, we must initiate Baker Act to have them evaluated for a minimum of 72 hours. At the end of that 72-hour period, they're either released or they voluntarily consent to additional treatment, or a psychiatrist has to petition to a judge for a civil commitment. It's not enough, like let's say I had a client and my client was an imminent, I determined that my client was an imminent risk, and I identified or I warned another party that the client was maybe threatening to kill or something, and then I just washed my hands of it after that point. That probably wouldn't fly. That's kind of what this case was illustrating. The interesting thing though here is that in Florida, you guys have all probably heard of the Tarasoff case. I can't even remember if that's in my slides. It probably is in the next couple of slides. The Tarasoff case was a California case that clarified that that mental health professionals had a duty to protect those whose lives were at risk because of a client who was diagnosable with a mental disorder. So if a client comes in and says, you know, I'm going to go kill my wife tonight, then you have to protect that wife. Well, that was a California case, so it doesn't apply to other states. But some other states have adopted that Tarasoff standard in their own state. Interestingly, Florida is not one of those states. So those of you who practice here, we're not really technically a Tarasoff case. But what we do have here is we have a provision that protects a licensed practitioner against liability in the event that they practice their duty to protect. So if I choose to protect somebody, then I should be immune from a liability for breaching confidentiality. Now, of course, if you want to have a good ethical practice and not be sued in things, you should still exercise your duty to protect. But technically, you're not mandated to here in Florida. All right, Medina versus California. It is not a violation of due process to place the burden of proof on the party asserting incompetence, even if the party is a defendant. So this is an interesting thing. You know, in a criminal case, the prosecution has the burden of proof in substantiating their accusation, their claim against the defendant. It is the prosecution's duty to prove beyond a reasonable doubt that something happened. All the defense has to do is raise a reasonable suspicion. They don't have to prove anything beyond a reasonable doubt. Now, it's a little bit different, though, when a defendant says, hey, I'm incompetent, then the burden of proof is on the defendant to be able to assert or substantiate incompetence. So we default to assuming that people are competent unless we have substantial evidence that they are not competent. Does that make sense? So the Miranda case, you all probably know that case. It just simply is a case that clarified that when government is interrogating somebody, they have to be non-coercive in the sense that they ensure that the suspect understands their rights and can voluntarily waive them by informing them of their rights, and then asking them if they wish to proceed with answering questions, fully knowing what their rights are. Montana versus Engelhoff is another Supreme Court case. Defendant's voluntary intoxication provided neither an excuse nor justification for his crime. So, if you are under the influence of alcohol or other drugs, that is not a legal defense. So that's what that case clarified. And then O'Connor versus Donaldson, another Supreme Court case. A state cannot constitutionally confine a non-dangerous individual who is capable of surviving safely in freedom by themselves or with the help of willing and responsible family members or friends. So another case that helps to clarify the civil rights of individuals with mental illness. Perry versus Louisiana, the Louisiana Supreme Court ruled that forcing medication for the purposes of execution was not medical treatment. Anybody know the background of this case? Nobody? My recollection is that part of confining somebody, let's say that somebody is determined incompetent to proceed with sentencing, then a state can commit the person or confine them and provide treatment with the intent of that treatment making it so that the person would be competent to proceed. So simply forcing medication to somebody so that they can be executed would not constitute medical treatment. It wasn't enough to sort of meet that standard, if that makes sense. Santosky versus Kramer, another Supreme Court case. New York had a statute that parental rights can be terminated with a fair preponderance of the evidence. Support the presence of permanent neglect violates due process requiring clear and convincing evidence. Okay, so this was another case that this case bumped up the burden of proof from a fair preponderance of the evidence to clear and convincing evidence. So remember, this is another sort of think conceptually in your head, 51% versus 75% burden of proof. Shaw versus Martin. Preventative detention can never justify incarceration of a juvenile who's not been adjudicated guilty of a crime. And then we have the Tarasov case, which I've already explained to you guys. That is not a U.S. Supreme Court case. It's a case specific to California, but it had a substantial impact because so many states have adopted the Tarasov principle. So now we're going to talk about Daubert versus Frye, and then we're going to stop talking about cases. Because a lot of you probably just have your eyes glazed over, and I know this isn't the most exciting stuff for us to talk about when we go through some of these cases here, but we're almost done. So basically, the Frye standard, which remember the Frye standard, it's kind of outdated. It was really the standard in federal court from 1923 to 1993, and the Frye test was concerned with scientific knowledge only. The Daubert case applies to technical and other specialized knowledge as well. So let's look at some of the differences really. The Frye case basically said, look, the standards involved in this testimony have to be pretty much respected and widely accepted in the scientific community. And that was basically all it said. You had to pretty much say that the methods that you're using to substantiate your opinion, that they're pretty widely accepted, and that was the end. The Daubert standard, which is more consistent with the federal rules of evidence that have since been passed, which I think were passed in the 90s, the federal rules of evidence, it sort of upped the ante a little bit. It clarified some things, and one of the things it clarified was what makes scientific testimony relevant. And I think I actually had something I wanted to add that I didn't have on this slide. First of all, the judge under the Daubert standard is ultimately the gatekeeper of whether or not a person is a qualified expert witness and whether their testimony is considered expert testimony or not. That was not the case with the Frye case, but the Daubert case clarified that ultimately the judge is the gatekeeper. He or she is the person that you have to convince. And the judge should consider the following things. Number one, whether the theory or technique from the expert witness can or has been tested. Number two, whether the theory or technique has been subjected to peer review and publication. And number three, the known or potential rate of error for a particular scientific technique. And then finally, number four, whether the theory or technique is generally accepted in the relevant scientific community. The same, number four is basically the Frye standard. But so as you can see, this adds some other very specific things that the judge can use to determine whether or not somebody's testimony is legitimate as an expert. And so there's an emphasis on empirical testing. Under the Daubert standards, for example, to illustrate this, let's say that it was, let's say that it was 1980, and my guess is in 1980, projective sort of psychodynamic kinds of tests like the Rorschach test were probably more widely accepted or widely used, at least among psychologists, than they are today. Well, what are some of the flaws of those tests? Well, some of the flaws are that they're more subjective in nature, and they're not as well normed. So it's harder to really be objective with those tests. They're more subjective. So under the Daubert standard, you would really want to avoid those projective tests or de-emphasize them and focus on more objective tests like MMPI, PAI, and so forth. Does that kind of make sense? Yeah. All right.
Yes.
I think I have a couple just to kind of check in with you guys on some of these laws that we just talked about. I have a few trivia questions I'm going to throw up on the screen here. The first one, let's see here. Which of the following landmark cases provided the first appellate case to give substantive test for insanity? All right, so basically we're asking which of these cases was the first case that gave us some kind of a test that deals with competency. So I have thrown it onto the screen. Option A is James Frye versus U.S. B is Rex versus McNaughton. C is Jablonski versus U.S. D is the Dusky standard. And then finally E is Durham versus U.S. Looks like only 25% of you have voted so far. So I'm going to give you a moment to select your option. Which was the first case to give us some standard dealing with insanity? We're at 50% of you voting. Give you a moment more. People are like Googling it right now, probably. No Googling, no cheating. I won't know who answered what. All right, so I've got about 70% of you having voted. I'm going to go ahead and close the poll out at this point. And let's look at what you guys said. Looks like the most popular answer was D. 36% of you said the Dusky standard. And the second most popular answer was 27% James versus Frye. Unfortunately, you guys are wrong on this one. Let me ask you this. Do you guys know which of these cases came first on sort of the timeline of cases? Anybody want to guess which case came first? The answer is 9% of you had it. It's B, the McNaughton case. This was a case, it was actually a case in the UK in the 1800s. And this case is sort of seen as the earliest case that gave some standards involving insanity in the courts.
They probably didn't have it right because McNaughton also was spelled N-A-U, so there was probably a...
Oh, yeah, you're right. I have a typo on the screen. Okay.
Well, I'm not sure. I've seen it both spellings, so...
Oh, okay. Yeah, I thought it was AGH, but come to think of it, I think you're right. I think
I've seen both
specifically
spellings.
said it's been spelled twice in one of the trainings that we did at before. But
Right.
So this is actually one of the sample questions in your study guide. So let me throw up another one here and see what you guys think about it. Let's see here. We'll do this one. The question is, strangely enough, I actually can't read the question right now. Let me expand it so I can see it better on my screen anyway. You know what? It looks different on my screen than it does on yours. You guys see it as a full screen right now. It's cut off on my screen. Can somebody read the question out loud?
The current controlling standard pertaining to the competency to stand trial was established by Dusky versus U.S., Jackson versus State of Indiana, Donaldson versus J.V. O'Connor, Tarasov versus Regents of University of California et al., and lastly, Addington versus State of Texas.
Okay. So far, I think only one or two people have voted on this. You guys are afraid to vote after the last one, I think. So I'll give you a moment. Looks like we have some more people chiming in right now. We're up to about 40% of you having voted now. The current controlling standard. All right, 63% of you have voted. I'm going to go ahead and now we're up to 70%. I'll go ahead and close the poll out now, and we'll show you what our results are. The most popular answer is Dusky versus US, with 64% of you voting for that. And then all the other options, exactly 9% of you voted for each of the other options. So Norm, which is the correct answer?
Oh, jeez, I don't know. Go ahead.
I'm asking you because I lost my screen again. I don't know what's going on, but it's
It's
cutting
either
off.
Dusky or Jackson.
It's Dusky.
And don't they
There we
both
go.
have to do
Okay,
with
I now have
competency?
access to it again. The current
Don't
control.
they both have competency issues?
Mm-hmm. Yep, I would say Dusky, because remember we were just talking about the Dusky case as being the landmark case that really solidly established what we're looking for when it comes to competency to proceed. Florida, we actually write in, we very specifically use the Dusky standards here.
That's correct.
For competency. So that is the correct answer. You guys were right on this one. All right, let me see if I have one more to throw up. I'm trying to give you a sense of what questions you might see on the exam when you get to that portion here.
But you will have competency questions in the landmark case. Absolutely.
Mm-hmm. You know, I'm going to need a quick moment here because somebody has a comment. Let me see what we have. Okay, there we go. Cool. Let me see what else we've got.
Do you want to take a 5-10 minute break?
You know, let's go ahead and do that. I lost something on my screen. I'm going to have to figure out how to get it back. It'll probably take me just a moment
And I'll
to do
stop
that.
the recording. Just remind me to start again because I always fail to remember.
Good point. All right. So we'll go ahead, folks, and we'll just take like a quick 5-minute break, get a stretch or get a use a restroom or get a cup of coffee or something, and we will be right back.
Good.
Aaron,
Yes.
this is Jim Pukta from New York. I was just checking to make sure that my microphone was not muted.
All right. Your microphone is not muted.
Now, I'm totally blind, so I'm not sure what I click on to mute it.
Okay. Oh, I know why things aren't showing up on my screen right now. Okay, so you're not sure what you click to mute it. There are some icons on the left side of the GoToWebinar rectangular panel. And that includes an icon that has a microphone symbol, and it's green.
Does it show an equivalent, like a keystroke equivalent?
It does not, unfortunately.
Hmm.
Yeah. The
And
good
I'll
news.
just be very.
Okay.
You can't hear my computer, can you?
I have not heard any background stuff from you, so
Okay.
far you're good. Now let me offer you an option, though. If you would like, I can unmute you, but then it'll be hard to get you back on because I might not know that you want to talk. So that's the risk you run, is if you do want to talk at some point during the
Well,
webinar.
as long as you can't hear my computer, I'll just try and be ultra silent here.
Okay, sounds good. That works for me.
Okay, thank you.
Yeah, no problem.
I'll be right back.
And get it going on yours.
I did forget. I'm glad you said something.
All right. Okay, so we are back, and I've got just a couple other sample questions, some polling questions I wanted to throw up on some of the stuff that we have talked about. The next one here, the question is, which tests are preferred by the under the Fried standards? Which tests are preferred by the courts with regard to meeting the Frye standard? And your options are A, the Wechsler scales, B, Rorschach ink blot test, C, the Bender-Gestalt, and D, MMPI-2, or E, A and D? I'll give you guys a moment to chime in on that one. Which tests are preferred by the courts with regard to meeting the Fry standard?
It's not allowing me to put in my vote.
Yeah,
As
it's
an
probably
organizer.
because you're an organizer, so you're not allowed to
Yeah.
vote, I guess.
Right.
I can't put in mine either.
Oh, you can't?
No.
Uh-oh. Well, it looks like we've got about 63% of people have cast a vote somehow one way or the other, but it sounds like some of you are having a hard time being able to cast a vote. But I'm going to go ahead and close things off here with 70% of you voting.
Got it back.
And it looks like the most popular response was E, with 73% of you saying both the Wechsler scales and the MMPI-2 would be good examples. And you are correct. The right answer is E. We'll do it one more sample test from the written exam here. Let me pull up. Well, actually, we'll do a couple more. This one is going to be a question about malingering. Let me pull it up. I'm going to pull up on my tablet because I'm having that screen issue. Malingering is a significant concern in the following types of cases evaluated by the forensic mental health evaluator. A, child custody. B, competence to stand trial. C, personal injury. And D, none of the above. So which of these types of evaluations do you think malingering is going to be a major concern? We got about half of you having cast a vote here. I'll give you a moment longer to decide. Okay, we've got, looks like 63% of you have cast a vote. I'll go ahead and close this, 70% of you looks like now. So I'm going to go ahead and close this one out. And the most popular response was C, personal injury, with 73% of you who voted. Sorry for the typo there on that, by the way. And you are right. That is the answer, personal injury cases. One thing I know, Norm, that you've said repeatedly is that, and or maybe it wasn't you, I think it was you, though I know a lot of people that we've trained with have said this. Personal injury cases, think about what do people have the incentive if they're going to distort information in one direction or the other. What are they highly incentivized to distort the picture towards? Mm-hmm. And in the case of personal injury cases, the worse they look, then the better their chances of getting some kind of settlement, right?
Right.
So they're highly motivated to fake bad if they're going to be faking at all. So personal injury case, two phrases, negative impression management, and then the second phrase is positive impression management. So positive impression management is I'm trying to make myself look better than the actual clinical picture would warrant. Negative impression, I'm trying to make myself look worse than the actual clinical picture warrants. Disability cases and personal injury cases, sometimes you're going to see some negative impression management. Now, on the other side of the fence, what would be an evaluation that you would see the opposite, positive impression management, meaning that the person might be highly incentivized to make themselves look a lot better than the true clinical picture would warrant? Who has any ideas about what types of evaluations we might see that with?
Child custody.
You've got it, child custody.
Child custody.
Yeah, it's so the if there's going to be some kind of distorting in the picture, a child custody case, my job is to make myself look wonderful and make the other parent look terrible, right? And then in a personal injury case, I want to look like I'm a mess.
And remember the NBFE credo: believe nothing, trust no one.
There you go, exactly. Now, also substance abuse evaluations. What do you think about those? Are people going to go the positive impression management direction or the negative impression management direction?
Positive.
Yep. Generally speaking, they're going to go positive impression management, but there's an exception for that.
Right.
And the exception is if I think that I'll get a much lighter sentence by going the negative impression management route. I used to work in a corrections program for many years where we would have people that the judge would be giving them an option, prison or a long-term intensive residential substance abuse treatment program and a corrections program. And usually the length of sentence would be dramatically different because the residential program would be like 16 months residential, 6 months outpatient, and then some probation for a few years versus maybe 10 years in prison or something like that. So it's amazing how people will all of a sudden be like, oh my gosh, I smoke crack every day all the time. And then they'll get into the treatment program, and then we had to treat them once they're there, and they'd be like, oh yeah, I just lied to get in here instead of going to prison. So that would be an exception, but usually you're going to see positive impression management and substance abuse evaluations. All right, so I think I might have one more polling question. This will be another sample question for the exam. There is a typo on this question. The phrase is actus reus, and it's supposed to be ACTUS. This is a Latin term, and I'm asking you what it means. Does it mean A, the level of intent, B, the act of reason, C, the act of accountability, D, the actual physical criminal act, or E, the idea to commit a criminal act? I will give you a moment to think about that one and answer which of those phrases you think is the right definition.
As everybody is Googling.
Yeah, exactly. No cheating, no cheating. We'll never know who answered what. All right, we've got 70% of you have cast a vote. And it seems like with all these exam questions, we keep getting 70% of you. So I'm going to go ahead and close it out and share the results with you. The most popular answer was A, the level of intent. It's actually D, the actual physical criminal act. So this would tell you, good idea to go hit that glossary in the back of your written exam study guide and be familiar with some of those terms. It's page 7 of the glossary of terms, actus reus, the actual physical criminal act. So whoever that 9% was, it got that answer right. Good job. Okay, so I'm going to get back into the slides here. And now we're going to go a little bit more in getting outside of law, and we're just going to cover some stuff about some of these other domains for about another 20 minutes or 30 minutes, and then we'll start getting into the oral exam here. So domestic violence, there are several statistics in your study guide that deal with domestic violence. If I remember correctly, I'm pretty sure that I was asked a statistical question about domestic violence when I took the written exam. I don't remember which question it was, but I remember being asked it. So make sure that you know those domestic violence statistics that are in your written exam study guide. Here are some examples of some of those stats. Nearly a third of American women report being physically or sexually abused by a husband or boyfriend at some point in their lives. 503,000 women stalked by an intimate partner each in the U.S. Or that's supposed to be each year. That's a typo. Overlap between child maltreatment and women battering. Child abuse occurs in 30 to 60% of family violence cases that involve families with children. And another stat, women are 5 to 10 times more likely to be victimized by an intimate partner than men. So you may be asked some questions about some of those statistics involving domestic violence. Chemical dependency and substance abuse. I remember being asked on the exam, I think they gave me a particular substance, and they said what type of, or this substance would fit into which category, basically. So that's why I threw this up. What I did was I threw up from the DSM, what are the different categories of substances that are connected to substance use disorders. Alcohol is a depressant, caffeine is a stimulant, cannabis is interesting because it can be three different categories: stimulant, depressant, and hallucinogen. It increases your heart rate, but it also slows down a lot of nervous system functioning, and it can be mildly hallucinogenic, distorting perception of time and space and so forth. Hallucinogens, we gave some examples here of what those are. Inhalants, opioids is another category. That includes your prescription medications that are painkillers and heroin and morphine and so forth. Sedative, hypnotic, or anxiolytic medications, benzodiazepines, barbiturates, sleep aids. Rule of thumb, when I used to work in residential substance abuse treatment, was if a client comes back on property and they look like they're drunk but they don't smell like it, then they probably took some kind of substance from this class. That was a rule of thumb. Stimulants, speed things up, amphetamines and cocaine. Tobacco, which is also a stimulant. And then there's an other or unknown category allowable in the DSM as well. So make sure you know your different categories of substances. You might get asked the same question I got asked. As just a side note, I threw on some examples of tests for substance abuse. I really like the SASI-3. I like it because it detects inconsistencies and random answering patterns. It detects high levels of defensiveness. Not that defensiveness necessarily means that somebody is distorting information, but what it also does is there are combinations of escalated scales that give you a picture that not only are they being defensive, but they're probably hiding some kind of alcohol or drug-related problem too. So it's also designed to pick up on subtle attributes that people with substance use disorders tend to have differently from people without. Sort of like, you know how on the MMPI there are some items that can escalate a psychoticism scale that don't have face validity, meaning that at surface level the question doesn't have anything to do with the symptoms of a psychotic disorder, but for some reason we don't fully understand. People with psychotic disorders will tend to answer that question differently than those without. Well, the SASI does the same thing. So it's a pretty good test for more forensic application compared to the older tests like the MAST, for example. I was specifically asked in the oral exam, why did I use the SASI-3 versus, say, a test like the MAST, the Michigan Alcohol Screening Test. But I was able to defend that answer, and when we get to the oral exam in a little bit, I'll tell you how I responded to give you a sense of what might help prep you for the oral exam. I also use the Maryland Addiction Questionnaire, but I would caution you do not want to use it as your primary test. The reason I use it is that it supplements the SASI by also picking up on defensiveness and subtle attributes and those sorts of things. But the reason its weakness in forensic purposes is that it is normed for a clinical population. So it sort of assumes that the person already has a substance-related disorder. So I use it more for, I've already concluded that they have a substance-related disorder using other methods, and now I'm answering a question that deals more with treatment because it gives you a good idea of what kind of treatment they might need. It's a really interesting test. And I think urinalysis drug testing is a must when it comes to substance abuse evaluation. And here's some other options that some other people use. And of course, collateral sources are essential because of the tendency towards positive impression management. Moving on to competence to stand trial. I gave Florida as an example on here, the Florida Rules of Criminal Procedure, and essentially when you look at this and then you look at the Dusky standard that we previously talked about, you see tremendous overlap because basically Florida has adopted the Dusky standard. So if the expert shall first consider factors related to the issue of whether the defendant meets the criteria for competence to proceed, that is, whether the defendant has sufficient present ability to consult with counsel with reasonable degree of rational understanding, of whether the defendant has a rational as well as factual understanding of pending procedures. So do they understand the charges raised against them? Do they understand the the implications for those charges and the possible sentencing or penalties for those charges? Do they understand the roles of the people involved in the court case, the jury, the judge, the defense and prosecution? Those sorts of things are going to be really important. And then if the expert finds the defendant actually being competent, then there are several other things that the expert needs to comment on in their report. But for those of you who don't practice in Florida, of course, you're going to have to look at what the standards are in your state. Just some more information about evaluating the defense ability to understand proceedings. Like I pretty much mentioned this in the previous slide when I was talking about that. And here's something I didn't mention though in the previous slide. Can they behave in an acceptable manner in the courtroom? And so again, this slide illustrates how here in Florida we use 6 factors that very much connect to the Dusky standard. By the way, for those of you practicing in Florida, if you want to do competency evaluations and you want to be on the list that the judge can use to appoint you to perform the evaluation, then there's a mandatory training that you have to take here. And if you want information on that, you can email me and I'll send you some stuff. But you don't need to have that training to do competency evaluations that were referred to you by attorneys. It's just to be on the court-appointed list. So here from your guide, these are the MBFE's recommendations for what you should include in your competency evaluation report. You can look at all that later if you'd like. These are some examples of some competency tests. I have the fitness interview test revised, which is really structured interview. And it's very affordable too, by the way. And then I also have the MacArthur Competence Assessment Tool for criminal adjudication. That one gives a lot of hypothetical scenarios to see how the person can answer those, whereas the FIT-R is less hypothetical in nature. So I think they supplement each other really well. But there are other options that you have in here. This was just an interesting thing. I found a study that looked at competency evaluations in the state of Florida, and I forget, I think it was some point during the 90s that they were collecting this data, but I forget the span of time. I have the full article on this, but you know, 3/4 of evaluations were conducted in jails. So that's the setting that most competency evaluations here in Florida are conducted in. And about half, or close to half, of those evaluators are appointed by the court, and about another half by the defense. It's rare for the prosecution to be appointing the evaluator. In 90% of cases, let's see here, competence to proceed 90%. In 90% of cases, they concluded that the individual was competent to proceed, I believe. I might have a, yeah, let's see here. Average length of time per evaluation. Oh, this one really surprised me. The average length of time per evaluation was only an hour and a half. I'm thinking, can you really? I mean, is that really enough time to make that judgment call? But that was really interesting to me. And this one was a shocker to me, that only 20% of reports reference the use of one or more assessment tools. So 80% of the time, the report doesn't even say that they used any kind of instrument to help them evaluate the person's competency. I was kind of disappointed in the stuff that I saw in this study. Now keep in mind, this was during the 90s, so things might have changed, but I don't think they have, based on the guy who gives the competency evaluation training here in Florida, Dr. Randy Otto, and he's one of the big gurus in the field of competency. He continues to review lots and lots of competency evaluations, and he says that still the majority of reports don't include any information on testing. So it's really surprising. Anyway, That's a little side note, I guess. Personal injury malingering, like the sample question from the exam that I threw up earlier, malingering is often going to have to be something that you're considering, or it's always going to be something you're considering when it comes to personal injury cases. Avoid psychobabble and legalese. Anytime that you are working on your report, and we'll talk about this more when we get to the oral exam, you got to keep in mind, what is the audience? Who's going to be reading this report? So you don't want to impress people with your in-depth, psychological terminology and so forth, because that might not be very useful for judges and attorneys and jury members. I would recommend for the exam that you review the diagnostic criteria for post-traumatic stress disorder and acute stress disorder, and that you know differential diagnosis. So it's important that you know what's different when somebody's diagnosed with ASD than with PTSD. Anybody know off the top of their head what's the difference between the two disorders?
Length of time, I think.
Yep, length of time. Does anybody know what that length of time is?
6 months.
I think you're right. I don't even know for sure, but in my head 6 months popped up immediately, so hopefully that's really it. If anyone wants to look it up and then chime in and let us know later, then you're free to. Examinees involved in personal injury cases are often motivated to sell you on the idea of pathology and suffering. So it's important to have lots of collateral sources and to have, I think it's important then to have a lot of objective testing in place as well. There's some pretty neat tests that help to give you some clues as to whether or not the person could be malingering. But there are also some signs of malingering. So here we give some of those signs. This is straight out of your study guide. Verbal aggression, defensiveness, and vagueness, especially when describing the exact deal or exact detail of what happened. Evasive responses. They're really suspicious of you. They're very negative and they overreact. They have heavy financial incentives. They have a history of problems with work and dissatisfaction with their jobs, a lot of absenteeism in their past, a lot of refusal of job offers in both the present and the past, history of claims for damages, reporting of nightmares that detail the trauma with exact detail, because that's rare to actually happen, antisocial traits, contradictory responses, lack of cooperation with the evaluator. They've got plenty of energy to tenaciously pursue their claim, yet they complain of having overwhelming depression and anxiety and incapacity. And they maintain a lot of non-vocational pursuits while they claim inability to work. These factors, it's not that any one of these factors proves that somebody's malingering. It's that these are things that increase the likelihood. These are clues of malingering. And the more of these traits, probably the more these things that you're finding in somebody, probably the higher the probability that they're malingering. Here are some tests for malingering, or some indicators. One is if you're administering personality tests like the MMPI or the PAI and they omit an awful lot of items, they just don't answer a lot of things. And there are several scales on both of those tests that are designed to predict or correlate with malingering. And then here's some other tools available for you. I have the SIRS, the Structured Interview of Reported Symptoms. And again, just like substance abuse evals earlier, collateral sources are really important. Juveniles and forensic evaluation. The juvenile sort of legal system, its origins are rooted in the 1800s in Illinois. For juveniles, we are more likely to focus on rehabilitation than punishment. That's really what we're trying to do in most cases. A landmark case was Kent versus US, and we already talked about that earlier. Miranda does apply to juveniles, but like we discussed when we reviewed Fair versus Michael, probation officers are not attorneys. So just because a juvenile has to speak to their PO doesn't mean that, and is denied, doesn't mean that they've had their right for counsel violated. Mature juveniles can waive Miranda rights on a case-by-case basis, but understand that juveniles are more likely to confess to crimes they didn't commit, even in the absence of coercion, than adults are. And that's often because of their strong need for social acceptance and approval, and sometimes For some of them, intimidation by adult authorities. So there are a lot of things that can actually, I mean, just because a juvenile confesses doesn't necessarily mean they did it, obviously. The judge decides juvenile court cases versus a jury, and children as young as 6 can be reliable as adults when they're interviewed. Females tend to be more accurate than males, but memory deteriorates rapidly after 2 weeks. So here's just some stuff from some examples of facts in your study guide that would be good for you to know when you take the exam. This is on pages 12 and 13 of the written exam study guide. Parental alienation syndrome, a term first coined by Richard Gardner. Children are preoccupied with depreciating or criticizing one parent, and that denigration is unjustified or exaggerated. So we give a lot of signs that the child, that we could have parental alienation syndrome going on. So be familiar with those signs of PAS. And a lot of identifying manifestations. Some clues. How might this syndrome manifest itself? And there are 3
One word,
classes.
Aaron.
Sure. Huh?
Yeah, I was going to add that in court today, we try not to use the word syndrome because the psychologists have rightfully argued the point it's not a syndrome. So I generally refer to it as parent alienation behavior.
Okay.
Oh,
that's
the
good.
constructs that you're talking about, go in and talk about that.
Gotcha. All right, good point. So Gardner offers 3 different classifications, and this course is going to be very relevant for child custody or parenting evaluations. We've got the child who just will not take sides. They genuinely have warm relationships with both parents. And although they may prefer, one parent over another in terms of who they want to stay with, they would rather divide time between both. This is kind of an optimal situation in some ways. Or really, it is an optimal situation, I think. But second one is the child with an ambivalent preference. They overtly express a preference for one parent, but they experience a loyalty conflict, so they keep their preference secret from the other parent. I'd rather stay with mom, but I don't want to hurt dad's feelings, so I don't tell anyone. And then the third one is the child with a seemingly unambivalent preference. They have a pathological desire to be with one parent, and they state their unequivocal disdain for the non-preferred parent. And they seem sort of programmed or brainwashed. There's not a lot of logic necessarily or evidence substantiating their claims. Don't seem warranted given the information available. So despite ample evidence that PAS has gained general acceptance in the scientific community, and satisfies criteria for admissibility in court, many psychologists criticize the concept based on invalid data about many aspects of PAS. I know I was asked a question about PAS when I took the exam, so good thing to study on. Now there's a section in your manual for adult psychopathy, pages 14 to 17. It's much more common in men than women. You guys probably knew that. There's a typo there. It should be 3 to 1 instead of 3%. Oh, no, it's 3% to 1% of the general population, so it's not a typo. This is a profile offered by Cleckley in '76 of some of the traits for APD, but I would like to recommend that you read the entire DSM-5 section on antisocial personality disorder and that you get familiar with those clinical manifestations in the manual. So in addition to scales on some personality tests, like the PAI has antisocial scales, consider the use of the Psychopathic Personality Inventory Revised. I purchased this test, but I haven't yet started using it. I know, Norm, you use the PPIR, right? You're probably muted if, I don't know if you're trying to talk right now, but you might be muted.
There I am.
Okay, yeah.
Yeah, we had a seminar by the PAR rep, Julie Alexander, Dr. Alexander, and she did an hour presentation on that particular test. I've only used it about a half a dozen times, and the reason I probably don't use it as much because I have to work harder at scoring it and interpreting it. It doesn't come with a narrative, so I like my work at this age to get everything done easier, and but it takes a little bit more work for me to score it, interpret it, and so forth. But it's a great test.
Yeah. All right. Cool. So we'll just be a little bit longer on the written exam here, and then we'll move on to the samples and the oral exam portion in just a little bit. But sexual offenders, pages 18 and 19 of your manual. Most commonly, the offender is going to be immediate or extended family members when it comes to childhood sexual abuse. Children typically know and trust the abuser. Here are some physical signs, be familiar with those, and some behavioral signs. Again, these signs don't prove that a kid's been or is being abused, but these are signs that increase the likelihood that abuse is happening if they're noted. So study all that stuff. And there's information, I think we might even have a full section in the study guide on pedophilia, predominantly a male disorder. We sort of define, a lot of people get confused about something. They think that anytime you have somebody who's over the age of 18, yes,
Aaron, I just
yes,
wanted to add that there's a lot of secrecy also in the sex offender. A lot of the time frame fees need to be looked at too, because again, it's a secret. It's between us.
you got it. Yep, a lot of secrecy involved. Man, the number of my clients in therapy who talk to me about childhood sexual abuse that was never disclosed throughout their childhood, it's amazing how many folks have those stories. So pedophilia, some people erroneously believe that anytime you have someone who's over the age of 18 and they find themselves feeling sexually attracted to somebody under the age of 18, that makes them a pedophile. And that's not true. The question is more prepubescent. From a purely biological standpoint, it's not uncommon for somebody over the age of 18 to be able to feel some kind of sexual attraction, especially toward people who are in their late adolescence, some of whom might biologically look very much the same as people in their 20s and so forth. But we're talking about attractions to prepubescent children. Now, something to also pay attention to, I don't know if this really impacts the exam very much, but the DSM-5 did a lot to really delineate between paraphilias and paraphilic disorders, because having a paraphilia doesn't make somebody disordered. The paraphilia has to be causing the individual clinically significant impairment or distress, or creating a problem with them adapting and coexisting peacefully and healthily in the context of a society. So of course, if they're offending against other people, or they're distressed by the paraphilia, then that sort of, generally speaking, puts people into the paraphilic disorder category versus being paraphilic. But that's just a side note. So there's some, I tried to put some highlights from the study exam on this slide, and you're welcome to study it in greater detail later. Again, I suggest reading the DSM section on pedophilia as well. Some information about sexual sadism here. Individual achieves sexual satisfaction by physical brutality to the sexual partner, almost exclusively male. Here again, we have another, this also I think illustrates, though, there is a difference between sadism and sort of disordered sadism. There's one thing, I guess, when you have two consenting adults and they're excited by what they're excited by and they're not being harmed or harming anybody else, but we breach into the category of disorder at points when there's distress that's being generated for self and others. a lot of trauma in the history of people with sexual sadism, as you would guess. Here are some tests for working with evaluations that involve sexual offenses. These are tests I actually got from, oh gosh, is it Mark or Mike Dansker, who did the training with us on tests. He did an MBFE training. He's a CFMHE in Texas.
That's Mark.
Yeah, Mark, you're right.
Mark Dansker.
Yeah. All right, so some involuntary commitment information. You have 4 pages of information in your study guide on involuntary commitment. These are just some of the highlights that I saw from that text. 3 levels of commitment: inpatient, outpatient, and criminal. Parents patriae power, state can commit mentally ill persons. Know what that term means? And the 50s, from the 50s through the 70s, we saw some of these Supreme Court cases that greatly enhanced the constitutional rights of people facing incarceration. So know those landmark cases. O'Connor versus Donaldson is probably the most pertinent one to pay attention to. And this sort of gives you some, these are the criteria that must be met for somebody to be involuntarily committed. The best predictor of future hospitalization. Go ahead.
Aaron, are you talking about the Jimmy Rice Act in Florida here?
No, I'm talking about, this is a federal case, O'Connor versus Donaldson, a Supreme Court case.
Okay, but are you mentioning the Jimmy Rice here in Florida or not?
I haven't mentioned it at all, no, and it's not in this presentation at all, if that's what you're
Okay.
Do you want to tell us a little bit about it, though?
Jimmy Rice Act is based on Jimmy Rice, who was abducted by a sex offender and was killed by him, and offenders who are in jail but ready for release from criminal charges can be recommitted under the civil commitment known as the Jimmy Rice Act if they are considered a danger to self or others, or recidivism, which often is pretty high. And they are tested, and then they have to have a civil commitment hearing, and then they are sent to a facility in Arcadia where they remain and receive treatment until deemed ready for release, if that ever happens.
All right. Good background information about, and specific here to Florida, for those of you who are in Florida. And it's the, did you say the Jimmy Rice Act?
Yes,
Okay.
Jimmy Rice,
Yeah.
who was abducted when I think he was 8, and the family, after he was found dead, pursued and started the Jimmy Rice Act, and it went to the government, and Florida adopted that as a way of protecting young children against sex offenders.
Yeah. Sad case.
Very. Thanks.
Yeah, no problem. Thank you for sharing that information. I told you guys I don't do these types of evaluations. I'm assessing for potential for violence or violent risk going forward. But got some little bit of information here. History of violence is a really important predictor or factor when you're assessing violent risk. Substance abuse increases probability of violent risk. Active psychosis does, being younger, under the age of 30, because we experience some hormonal and behavioral changes oftentimes as we age. A diagnosis of APD increases risk, of course, that just kind of makes sense. Post-discharge complications. So this would be somebody gets discharged from treatment and they're having a bunch of complications when they're trying to settle into back into society, so to speak. And then here are some tests that might be helpful for those of you who do these types of evaluations or will be doing them. All right. So that concludes the portion today for the written exam prep. So I'm going to pause here for a moment and just see if any of you have any particular questions about the written exam or preparing for the written exam before we get into the oral exam portion. Any questions out there?
I'm just a little confused. Are we going to get copies of this slide presentation?
Yes, there are two ways that you can get copies. The first is that if you, right now on your GoToWebinar panel, you should see a heading that says handouts. It'll probably say something like handouts 5 of 5 or something like that. And if you click on the plus symbol to the left of handouts, then it'll expand that box and it'll allow you to download those handouts at any point during this presentation. But I'm going to go ahead and also send a follow-up email to you all that has all the handouts just to be on the safe side.
Okay, I would appreciate that because I'm not at a computer where I can download things.
Oh, okay. I think I'm also going to set up a link where I'll keep the most updated version of all of these materials so that at any point you can download those. So I'll include that information in the follow-up email I send after our webinar, which probably won't go out until later this weekend or maybe even Monday next week or so.
Okay, thank you.
Yeah, no problem. Now, while we're at it, I've had people ask, one common question that people have asked me is, hey, which books should I be studying with? Now, first, let me clarify something. If you feel pretty confident about these 20 domains, you don't have to read any books. I don't think that you have to read books to pass this exam. That being said, of course, it doesn't hurt and it can be helpful. My personal opinion is that a lot of people out there are delaying the exam excessively. They don't really need to delay the exam as much as they are. Maybe some people are just kind of nervous about it, so they may be they're spending too much time preparing, and I think it's better to take the exam within a few months of becoming a candidate. And so I don't think you need to read a whole bunch of books or something in order to do that. But let's say that you say, look, I would feel more comfortable if I read a book. What's the book that I would most recommend that you read if you're going to read a book? It would probably be Ackerman's Fundamentals of, let's see, Forensic Mental Health Assessment, I think it is. I'm going to see if I can pull it up right now to show it to you. Huh. Well, I'm not pulling it up very easily. Why not? It's on your, you should have actually a list of books. Let's see, Ackerman Forensic. Let's just do that and see what pops up. You should have a list of books. There it is, Essentials of Forensic Psychological Assessment. Oh, let's do the Amazon link actually. Let me go backwards. Because I have it on my Kindle. The reason I have it on my Kindle is that I really like being able to keyword search in my forensic library, and so having it available electronically helps me to do that. But it's you can buy a new copy of it for, oh, it's more expensive than I thought. It's like $30. It's a pretty thin book. It's not very lengthy, I don't think. But if you were going to pick just one book that you really, because you really want to read something before you take the exam, I think this is a good one to read. I got the Kindle version, so I'd be able to do keyword searches and things like that. And if you want a second good example of a book, the second book I'd most recommend is Petrilla, I think, is one of the authors. Definitely Randy Otto is one of the authors. It's Psychological Evaluation and for the Courts, I think, or something like that. Let me look it up. There it is, Psychological Evaluations for the Courts, 3rd edition, a handbook for mental health professionals and lawyers. They also have a Kindle version of this book. It's a pretty expensive book if you buy the regular version of it. I wonder how you get onto the, let me see if I can find the electronic version. It might be cheaper. You can buy a good used copy, probably hardcover, for pretty cheap, but it's $103 on the Kindle. Man, I spent a lot of money on that book. Those are the two books I'd most recommend if you're going to do some reading. But I would suggest you not wait too long. Feel free to, now something to keep in mind, and Norm, you might want to chime in on this. When I was prepping for the written exam, if I remember correctly, you told me that if I were to not pass the exam, that I would get some feedback on my weak areas. Is that correct? And is that still
No,
something?
no, it isn't.
Oh, that is
Uh,
incorrect. Okay.
Now you're just given a score. Generally, we don't go back and look at what was weak because actually we don't have a process to do that unless we did it manually. It would probably take us quite a bit of time.
Ah.
We can only tell you that you had 73%, 65%, or something like that. It'll be up to you to go back to the study, the recordings that we've done on previous. We do other recordings go through the entire written exam, so we would recommend you go review those recordings again, because they're pretty thorough on just the written and only the written, and that should help whoever it is it's weak in an area, strengthen it.
Okay.
Are
So the
those on the
feedback
web
you'll
page?
get is what your score was, basically. How close were you to passing or not?
Correct.
Somebody else was about to make a comment too?
Are the recordings on the web page?
No, we will make that available since you're a new candidate, Jim. I think it's Jim.
Yeah.
I will send that oral and other recording information. Aaron will prepare this one and convert it, so this will be a valuable one as well. So we have several different ways of studying for the written and oral exam.
Right.
This is probably the most thorough one that we've ever had, with Aaron dedicating an incredible amount of time preparing this one. So this will be 1 4-hour recording, and then we'll have the other 2-hour recording that we've done before.
Now we do have a question that was asked through the chat box or through the question box, and it's from John, or actually Jack Jones Jr. And it's, can you tell us the process of taking the exam? Email Dr. Norm, how many hours we get, etc. Norm, do you want to tell us a little bit about that?
The question, how many hours you get? Does that mean how many CEUs?
He'd like you to describe the exam process, and he
Okay.
gave some examples of things. How do they register to take the exam, I guess would be the first question.
When the candidate has ready to take the exam, they email us and they request what date they want. You'll have 24 hours within that day to take the 3-hour exam. You get 3 hours. Most people take it and complete it within a couple hours, an hour and a half. It's a 100-question, as you said earlier. There are categories. For instance, domestic violence, there are 6 questions. Substance abuse, 5 questions. And on. I can go over that, but I don't want to take that time. The questions are, there's always 5 answers. Usually 3, of course, are answers that should be obvious that they're not they're correct or not. But they are scored. They have been researched by a research psychologist. We have about 1,000 questions, and every question has been researched and has been given weight by the research psychologist, so that we do have a structured, verifiable accountability of every question that we ask. And they are changed periodically, and new questions are put in the test. But when we do the study guide, as Aaron is doing right now, he's covering all the different areas that are absolutely essential to study for the test. There are no surprise questions. They're exactly, there are sexual abuse, juvenile justice, parent alienation, landmark cases, and it's an open book exam, so you will be able to cheat, if we call it cheating, but it's an open book, because you're going to be taking it on your own computer, and we will give you the link to enter, and the invitation will be linked, so you'll have that link. You go in and give your password, username, and then once you start the test, the timer begins, and you have 3 hours to complete.
So when you think about it, 100 questions and having 3 hours to do that, that's a pretty good amount of time to get through those 100 questions. But if you're going to be doing a lot of, if you're going to be doing open book sort of approach, then that might be another story. Really good to be studying this stuff and to have a lot of this down.
if you go through the recordings and the training that we've done in the past and this current one with Aaron, I don't see how you should do poorly on this test. We are now mandating that all applicants must have their application in within 90 days. We have people who have not even submitted after over a year. They will be disqualified if within a week we don't get them. There are a few people that are outstanding. And within 90 days of the application, you'll have to take the written examination. There'll be no exceptions anymore. We're mandating this. And after the written examination is passed successfully, you'll have 90 days to submit your samples. We're not going to allow a year and a half, 2 years to go by. And first of all, that's the wrong way to approach it. If you're like me, you would have taken it yesterday. And like Aaron, he took it very quickly. He was exceptional in his responses. He was probably probably that's why he's the chair of this, because he was so good at it. He's one of our premier people, and we're proud to have him as chair of this committee and training. And I am so happy that he is doing what he's doing. But there'll be no more exceptions. All those people we just trained in Philadelphia, you have 90 days to get that application in, and we got to have it. And if you're not going to have it in, we just feel you're not very serious about the process, because you spend a lot of money to get the training and go through it. Let's take it seriously.
Yeah. And you know, I I mentioned this earlier, but my opinion is that people excessively drag their feet on taking the written exam. It's not as overwhelming or difficult as you probably think it is. And I think people are probably, if they're going to be off a little bit, they're going to be off in the direction of being underconfident rather than overconfident about their ability to pass the exam. So do some studying, review the exam prep materials, and watch the videos again later on to maybe review and take the sample exam questions, answer those questions and see how you do on them from your manual. Look back over all your notes from the workshop and take this exam relatively soon rather than waiting too long while you have the information in your mind. And that's what I would suggest. I think people drag their feet on it too much.
Yeah, we just had 11 new candidates from Philadelphia, now from the East Coast. We're getting great numbers from that area. It was a great class, beautiful
Great.
attendance, and bright. We got real bright people who are coming out, and we really have to. I have to impress you. Get your application in, please. Don't wait for your reference letters. That's always last, but get the rest of it done.
You know, one other thing I've noticed that there's some situations where people they're concerned about the number of hours of experience that they have to include in their application. And I've had, you know, some of my mentees, they weren't considering some clear forensic experience that they've had in the past. Because I guess some people have I mean, you don't have to be on the stand for your hours to be counting. Anytime that you're conducting an evaluation that's going to be used for the courts, all of that time interviewing the client, the time creating the report, the time reviewing your collateral sources, all that stuff, that's time. That's on the clock time. And then all of the trainings that you do, what you're doing right now is counting towards your hours. So, so really just think about all the experience that you have that's related to mental health in the courts, and give yourself credit for those hours. And
Yeah, one class is 40 hours. It's a three credit hour class is 40 hours.
Yeah. Yep, there you go. That's true. So you'd be surprised how quickly those hours start to rack up when you really think about this more holistically, and you look at your forensic experience.
I just remember this. We have Howard Carroll, who is luckily he's attending. He's the chair of the oral examination committee. We have Dr. Watt, myself, Pamela Ballantyne. Many of us had over 1,000 hours and more. You know, that's almost like you expect to have that kind of hours in. We're talking about thousands and thousands of hours of people who are training you. So you take advantage of that. You know, just wipe us dry, get all the stuff you can from us.
Yeah. All right, so now probably at the end, I'm going to give you my little quick spiel about there's a project I'm working on to try and improve our partnerships with professional associations, and I might need some information from you that could be really helpful with that. So I'll tell you about that at the end of today's webinar. But I think probably we took a 5-minute break earlier. I'm thinking this would be a good time, maybe take a 10-minute break, and then we will truck right on through to 4 o'clock after that break, focusing on the oral exam and the written samples for the rest of our time today. So I will see you guys back here in 10 minutes. Sound good?
Thank you.
All right. And then you want to make sure that you remember to start the recording on your end as well, right?
I got it. Thanks.
Okay, great. So let's pick up with the oral exam here and the written sample portion.
Is everybody back? Because I just want to make one little comment that Dr. Val, and I'm sure Howard, if he's here right now, would like me to say. Howard, are you here?
Let me look for Howard on the list here. Yeah, Howard is on and he is unmuted.
Yes, I'm here.
Okay. I hope we have everybody else, you think? Because everyone has to hear this. Can we do a roll call?
Yeah, let's see. How about this? I almost said, raise your hand if you're not here.
They can. They can raise it. Oh, yeah, right.
Good luck with that.
Yeah. We could. It looks like everybody's active right now. I'm looking at. There's a. This program's kind of Big Brother-ish. I can tell that you guys are like doing other things on your computers and stuff. I can't see what you're doing, but I can tell that you've minimized your screen and stuff like that. Looks like almost everybody is very attentive right now, so
Okay,
I
great.
think we're good.
You'll have to show me how that works because I don't know how to do it.
Yeah, I'll tell you later.
Everybody out there, please, and this is for Howard Carroll, and he can emphasize it after I'm through, and Dr. Val. For some reason, in spite of the training, in spite of Dr. Val saying this over and over again and me emphasizing it, the people who send in their samples still do not follow the headings. They add their own. They don't add things. We had a recent one that didn't even have identifying data. The very beginning, it didn't have the heading, forensic mental health evaluation. So when you see that outline that Aaron's going to go through, make it simple. You're going to get rejected if you don't do it. It's automatic. It's almost like trying to get disability. You'll be rejected right away. Howard, you want to say something about it?
No, I think that pretty well covers it.
Yeah, the headings are all there in black and white. The developmental history, the reason for referral, the developmental, the collateral, that stuff, and it bogs my mind. I don't understand why people will not put the mental status. Make sure you don't do a 10-page mental status. It's a very clear, easy paragraph. Anyway, I don't want to usurp your training, but that's it. And we still continually get samples that omit the headings.
Yeah.
Okay.
And on that note, just as a side note, something for us to look at, there is a little bit of inconsistency with the materials available to the candidates in terms of what the headings should be. The headings as they appear in the oral exam study guide and as they appear in the slideshow from the initial training that people do, and as they appear in the credentialing manual, there are a few slight variations in those headings. They're nothing big. They're not huge variations, but I think it'd be nice for us to make things very uniform.
Okay,
That's something
I
for us
think
to
you're
look at
absolutely
later.
right. But use the ones from the oral study guide. That's the latest one we just updated.
Okay. hopefully I used it in one of my upcoming slides. Hopefully it's the same as the oral study guide. I think it is, but
Okay.
but we'll double check that in a moment. In fact, I'm just going to open up the oral study guide so that I'll be able to catch it quickly if it's,
Good.
let me
Yeah,
do
we
this.
update them periodically because we learn ourselves what should be. We added 2 headings, psychiatric and abuse, or legal, I can't remember. But we wanted to add those because they're so important.
Yep, let me go to my box sync here. Where might that be? Box sync. And I'm going to go to research and training. I'm going to go to MBFE.
I was trained at Menninger's. We had a year internship, and we did a 3-4 page mental status. So don't try to impress us with your knowledge, because I would fail if I did that myself, just because you know how to do it to the great length of one. Just do the simple headings. We know you know how to do it, and when you're in your own private practice, do what you want to do. But you'll know that we want to be able to review it easily.
I'm pretty sure this looks exactly like what I have in my slides. So I'm pretty sure that we're good. Okay, good. All right. So let's do this. Nope, we don't want to do that. Let me get rid of that real quick here.
Did we have abuse in there, the last one?
This is the one that you just sent me that you said is the most updated one.
Okay,
so
let's go with
hopefully
that. I thought we had legal or abuse in that one, but maybe I'm wrong.
Let me do a couple things here.
Hey, Jens, can I ask a question real quick?
Sure.
Yeah.
Can you hear me?
Mm-hmm.
Yeah, I'm just a little bit confused between sample reports and the oral exam. I can remember when I sent in my data for the application, I included a couple evidence of
Who's
what
talking?
I had done in the court. Which
Oh, Jack.
yeah, this is Jack Jones. Hi, everybody. Yeah. So I thought that the oral exam was one 10-page, absolutely following the guidelines that you've outlined, and that's what we would be defending, is like almost like we're on the stand. I thought it was one forensic evaluation, whatever type you choose, and I thought that the written samples went in with my application, which showed some work I have done in the past that I would now do differently as a result of studying with you all. Can you just clarify that?
I'm not sure what you meant by samples in that you were sent. Yes, there are. You
Well,
have to. Go ahead.
No, that's it. You have to. The oral exams based on 2 samples or just one?
It's one that you need to send in. You're going to be sending in 2 from now on, and we'll pick one because we've changed the process from the mentorship helping you with that. So you're going to be making sure you got the right training, and you'll be submitting an oral sample, both 2 samples, to Mr. Howard Carroll, who will look at those and see if he can pick one that he'll be using for the oral exam. And the sample must adhere to the guidelines and structure that Aaron's going to present today. But yes, it's a 10-page on one person. Don't do it on 2 or 3 because you'll have to have a longer evaluation. Follow the guideline that Aaron's going to present.
Okay, thank you.
Yeah, it used to, the process, not very recently, the old process was you would first send in a sample to your mentor who would coach you on it, and then you would do a second sample that would go to the oral exam board or panel, and that would be the sample that you defend for your oral exam. But now we've changed it so that instead of having a mentor, we've got all these prep materials available to you, and then you'll send both samples in at one time, or both samples in anyway to the oral exam panel, and then they'll choose which one you defend for the oral exam. Is that right, Norm?
It goes to Howard Carroll, the chair.
Okay, Howard
It
Carroll.
doesn't go to the panel. He then reviews them and determines if the panel's going to accept one or not. And then the panel, Dr. Watt, then reviews the same sample that he's choosing, and they confer. I'm left out of the process. I'm only examining committee, so I don't get involved in choosing anything.
All right, so I think that covers it. Virginia Noy added the comment that there is the oral exam study guide. The newest copy should say updated June 14th or something.
That's
I
what I
don't,
thought.
maybe this is the old copy. Oh yeah,
Let
this
me
is the
see.
old one. Okay, let me
Yeah,
get
I
rid of
thought so,
this.
because I did update it and I put the date on it.
All right, so I think I have a separate file. So let me pull up
Let me see if I can bring it up. You want my copy?
I think we're going to be good in just a second here.
Okay.
Because I had two files. I pulled up the wrong one.
Is that going?
Oral study guide. I'm going to do the Word version because I think that's probably the updated one.
Hello? Hey.
So if you guys can bear with me for a quick second. Yep, here's the new copy. So never mind. Let me look at the new copy here for a second and see if any of it looks different than what I have on the slides, because if so, I'll have to update it. But let's see, reasons, sources, collateral, summary, psychosocial, developmental, medical, psychiatric, substance abuse. Yep, all this looks about right to me.
Aaron, could I ask a quick favor?
You sure can.
Okay, if you have that in a Word format,
Mm-hmm.
forward that to me because slides are very difficult.
I absolutely will. Yeah, I will forward this. In fact, when I send the follow-up email, I'll attach a Word copy of the oral exam study guide and send it out to everybody.
Terrific.
Yeah. Let's see. We got another comment here. There's one that says updated June 14th. Yep, we got that. What if you've never done a forensic evaluation before, somebody said. Let me see who asked that question. Carl Ross. Okay, Carl, so the answer to your question, Carl asked, what if you've never done a forensic evaluation before? If that is the case, then my recommendation would be, because you can use a fictional case for your report. You do have that option. It's more challenging, though. It's more challenging because how do you defend a fictional case where you have to make up a lot of information, and then you have to remember that the story that you've woven, basically. If you have a real case, it'll be easier to keep things consistent, I think. So what I would suggest is if you've never done a forensic eval and you're going to therefore be submitting hypothetical cases, fictional cases, then I would suggest you base it on one of your clinical clients that you have a lot of information about, so that the facts that you're reporting on are real facts about somebody. It'll be easier for you to defend it then because you'll have information in your head that you can access instead of remembering, okay, what did I make up as being the story here? Does that make sense? So in that scenario, I would take a therapy client that you've had that you have a lot of information about and try to develop a hypothetical forensic evaluation based on that individual. Now, of course, you're not putting, you're doing exactly what I did with mine, which is
Not using the real name, of course.
yes, you're altering all information that could, what I did, I altered names, I altered dates, I altered locations, I altered names of charge, like all kinds of stuff, just to be extra ridiculous about it. But yeah, you won't be providing us confidential information, but you can use the data from a real client that you've worked with, and that's what I would suggest doing. A client
Okay.
you know really well and you really know the story.
Yep, can do.
All right. So on that note, let's get back to the slides here. And I wanted to start off by just reviewing a few rules of thumb that I think are pretty helpful anyway. First one is to be succinct with your report. You do not want to have lengthy, flowy, colorful language and things. Think APA style, where you provide the facts and the information, the greatest amount of information in the smallest number of words. Think about it that way. You don't want to impress people with incredibly dramatic and in-depth personality interpretations that go on and on with a lot of psychobabble, like we said earlier, because these reports are are going to judges and attorneys and jurors. That's the population that you're writing for. So you want to minimize the use of psychobabble. And when you use clinical terminology, it's not a bad idea to define it in some way so that it sort of makes sense to the reader. And it'll be easier to defend it that way, to answer questions about it and explain it. And remember, you're wanting to be objective. You want to avoid subjective wording for the most part. Your conclusion section is where you're going to get a little more subjective, because here you're going to be offering your professional opinion based on the data available to you. And like I said before, I would suggest you use a real case, although you have the option of manufacturing a case from scratch. The problem with that is that it's going to be hard to answer questions. You're going to have to make up a lot of things. And then you might forget what you made up earlier, and you might end up with inconsistencies. So I suggest using a real case. And if, like I said before, if you haven't ever done a true forensic evaluation, use a clinical evaluation that you've done, or a therapy client that you've worked with and you have a lot of information about. But again, don't breach confidentiality. And so we got, remember your audience, and then proofread your report extensively. And then get a colleague to proofread it as well, or maybe two. I did that. I proofread mine, and then I handed it off to our office manager here, who is a grad student and a really good grad student. In fact, she since has left us and now she's a counselor. But she looked over the report and she found all kinds of errors that I couldn't see. Because when we read over our own reports, we see what we're thinking, not what we wrote sometimes. And so I definitely recommend that you have someone else look over your report and proofread it. If you do that, then you're gonna be much better off once you get that final product off to the panel here. So let's talk about the different sections in the report. Wait a second, I think we skipped something. Oh, we did. So these are the sections in your sample report. There are a couple alterations on this from what you have in the study guide, the most recent study guide that was released in June. So I'm going to try and go back and revise this slide to be 100% consistent, because I think the only difference is probably, let me look and see. Yep, here it is, item number 10. I said test results. That one shows up in your oral study guide as personality assessment, I think. My preference is to call that the test results section, but that's me. But for purposes of your sample reports, I would suggest you go verbatim by the headings that are in your study guide and make that personality assessment instead, that 10th item there. Okay, so these are your sections: the title and type of evaluation, client name, date of birth, case number. There's a typo, sources of information that's supposed to say. Identifying data, reason for referral, collateral, sources, summary of significant data, and then your psychosocial information, which should include things like your developmental history, medical history, including medication, psychiatric history, substance abuse, academic history, vocational history. Ooh, I see that we have a problem here. I've got collateral on here twice. So see, I need to go back to what's actually in the study guide and make sure that I changed this slide to be accurate. Something's wrong on it. And like I said, number 10 should be personality assessment instead of test results. And then your mental status, your diagnoses, or diagnostic impression, I think is the verbiage on your study guide actually. Then your summary, which is a dynamic formulation.
Ren?
Yes.
Ren, if using a case where the legal system is involved, under psychosocial information, would incarceration history be acceptable also?
Oh, yes, that would be very important. In fact, I'm surprised that's not on here. Let me check something out real quick. Let's go back to your study guide and let's take a look here, just to make sure I didn't mess up and exclude it on accident.
There's 21 items on that.
Oh, so something's wrong.
This is 15 in your slide.
Sources, collateral, summary of significant, psychosocial. Oh, well, the reason why you see that, though, is that I went and took psychosocial information instead of listing these as separate numbers, because these are all part of the psychosocial. These items right here, I listed as letters under number 7. So you will see a difference in the numbering. But remember, on your report, you're not going to have any numbers. You're just going to have the headings. I'll show you that in a moment because I'll be showing you a sample report here in just a moment. But I see here that there isn't a section that says legal history, and that's surprising to me. But I would definitely include a legal history under the psychosocial information, absolutely. Now, I covered a legal history in my sample report that I'll show you in a moment, but I'll show you where and how I did that as well. All right, so let's see what we got here. Oh, I know what's wrong. I was just showing you the wrong thing. I was showing you the old one because I forgot I have both a Word and a PDF file open right now. Let's go to the newest one. Well, still here we've got, we do not have the legal history on the newest version that was just released in June either. So there you go. And yeah, collateral shows up twice. Collateral sources and collateral information. See, I had put collateral sources under sources of information. I considered it part of that heading. So
Is that June of 2014?
Yes, this is the June of 2014 one. Let me show you the date up here at the top. Why won't it let me go to the top? Let me see what's happening. Let me get my panel out of the way so I can scroll better. That's probably what the issue is. Yep, there it is. Updated June 30th. Man, I got a lot of stuff in the way I've got to get out. June 30th, 2014. There we go.
Yeah,
All
but
right.
my June 30th has legal history, number 13 on my June 30th, 2014.
No way. All right, let me go in here and see what's going on.
14 or 15, did you say?
I've got
Yeah,
June
14,
30th,
yeah.
2014, yeah.
Mine says legal history 13.
I don't. That is strange. So we've got two different versions of even the same revision date.
Yeah.
So I'll get with Norm and we'll make sure that we just get the most updated one out to you all when I send the follow-up email. And that should take care of that, I think.
Yeah, because that one's a year old, and I'm sure we made a revision since then.
Does anybody have, I know Virginia, you said that the most recent you have is June 30th, 2014. Does anybody have something dated newer than that? Not hearing any yeses so far. Well, we'll see what we can find. We'll make sure we get the most recent one out to everybody when I do the follow-up email. All right, so back to the presentation here. What I'm going to do right now, I've lost my GoToWebinar panel screen. Let me see where it went to. There it is. Okay, it's back. I'm going to launch a poll right now. Just a little question to get your opinion on something. I want you to guess something here. The question is, which of the following sections do you think is the most commonly criticized section of the report during the oral exam? Your options are A, the summary of significant data, B, psychosocial self-report, C, the mental status examination, D, the conclusion, and E, the recommendations. So go ahead and take a moment and just guess which one you think is probably the most heavily criticized section, meaning that that we see people struggle with this section probably more than any other section. We see the most problems or flaws with it in comparison to all the other sections that you have options for here. Well, looks like we've got 75% of you having voted. 81% while you guys finish. I'm going to go over here and see somebody just sent in a comment. Let's see what it is. Virginia does have an edition that was revised in 2015. So I need to get that most recent version and get it out to you all. So I'll get that from Norm later. All right, 100% of you voted, so everybody has voted. I'll go ahead then and launch the results here. And it looks like the most popular section, or the most popular response was conclusion, 44% of you. Second most popular was recommendations with 25% of you. Now, Norm, are you on right now to share your opinion of which of these sections have been the most heavily criticized in the oral exams that you've been a part of? I'm not hearing you. Norm, if you are on right now and you're talking, you're probably still muted. Okay, so how about Howard? For you, do you have an opinion on which one's most heavily criticized?
I'm not really sure. I know Dr. Val finds a lot of problems with the mental status exam.
Yeah.
I can't really identify one section.
Okay, that's the one that I thought, because I think that's what Norm had told me before, is it seems like religiously that section is being butchered. So when I created this question, I had that in mind as being an area that a lot of people bombed. Well, interestingly, that's the one that the fewest number of you thought was heavily criticized. So that's a section to really pay attention to. There's been a lot of mistakes and a lot of weaknesses and flaws in the mental status exam. So I'm going to give you a good example of what the mental status exam should probably look like in just a little bit here. So what we're going to be doing is we will kind of take each of these sections chunk by chunk, and I'm going to use the a sample report to show you what this might actually look like. So we've got your type of evaluation, and you know, I'm always putting forensic mental health evaluation as the title on my report, and my understanding is that that's what the board would like to see. I'm going to try and show you here, though. Uh-oh, I think I might have accidentally gotten rid of. Oh, here's my report. Okay, this is the actual report that I defended for my oral exam, and this is a real case, although like I mentioned to you all earlier, I changed dates and names and locations and every proper noun and all of that good stuff so that I would really be able to protect any facts from the real case. But I titled it Forensic Mental Health Evaluation, and although I think...
We're still on the poll on the screen.
No wonder. All right, let me get that out of the way. So hopefully now you're able to see the sample report. Okay. So, so here's the sample report that I defended, like I was saying, and I have the client's name, date of birth, age. I always put the social security number on mine. The date of the evaluation, which is the date that I formulated my report, basically, and then the interview dates and the case number. And then I go into sources of information. Now, again, some of the resources that you see are contradictory about the ordering of the first few items. I think originally, before sources of information, I had presenting or identifying data in a couple other sections. And when I sent in my first report to my mentor, I was told that I had the ordering wrong, and I was told to put the sources of information first. But again, you know, you're going to want to go by the most recent edition of the oral exam study guide, which we'll be sending out to you, the most recent version after this webinar. And as long as you go by that, because you'll see here, identifying data comes before sources of information, and I have them after sources of information in my sample report. So even though my sample report does, I think, a really good job of covering all the content, the things that you're supposed to be talking about, the ordering is a little bit off at the beginning, so keep that in mind as we go through the sample here. Okay. So the sources of information, I list everything in a bullet point list. It's the way I like to do it, and I alphabetize it. I've got every questionnaire or structured interview, every test that I used. I've got my collateral interviews, and I've got my review of records, which are other collateral sources that are written sources. This is a guy who I had to review a pretty fair number of records as a part of the evaluation. And I even have a urinalysis drug test on here. The identifying data, Mr. Rhodes is a 33-year-old Caucasian male residing with his fiancée and her children at their residence in Largo, Florida. So here we're talking about, we provide some demographic information, the client's name, their age, gender and race or ethnicity, where they're residing, and all the samples I've seen, people seem to include, who lives with the client. I don't know if that's necessary or not, but I went ahead and added it to mine because that's what I was seeing in all the samples. The reason for referral is brief. And it's in this case, Mr. Rhodes was referred for a forensic mental health and substance abuse evaluation by the Honorable Judge Felix Fairview, who presides over a child custody case involving Mr. Rhodes and his ex-girlfriend, Hannah Pierce. Judge Fairview issued a court order requiring the evaluation on September 1st, 2013. Both Mr. Rhodes and Ms. Pierce's attorney, Acosta Lott, clarified that Judge Fairview did not order a parenting evaluation. Rather, the purpose of the evaluation is twofold. So in the reason for referral, you want to make sure that you identify what are the specific questions that the referral source is asking you to answer in this report. Number one, determine if Mr. Rhodes meets diagnostic criteria for any mental health or substance use disorders. And then the second thing they want to know is what, if any, treatment recommendations are appropriate. Both Mr. Rhodes and Mr. Lott verbalized an understanding that no opinion will be offered as to Mr. Rhodes' parenting abilities incidental to this evaluation. So here, this was a little bit of a unique case because this was a child custody case, a parenting evaluation. And yet, there's no parenting evaluation being conducted, which surprised me. Instead, it was just basically the mother of the child alleged that the father had all kinds of mental health and substance abuse problems, and the judge ordered an evaluation for the father, but not for the mother, nor an evaluation that answers questions about parenting abilities or appropriate placement. That's all I was told to do, was decide if this guy has disorders, and if so, if any treatment's recommended. That is it. So I added that last line intentionally just to clarify, make it very clear that I was told not to offer any opinion about parenting abilities, and that I will not be doing that in the course of my evaluation. All right, so any questions about the sections that we've covered so far before we get to summary of significant data? Nope. All right. Let me go back to our slide here.
By the way, Aaron, I did send you the updated one for June 20th or something.
Well, the one you sent me has June 30th, 2014.
Oh, maybe it was the wrong year.
Virginia says that there's a June 2015 revision. And then, I forget who else said that there was a section on their ordering for legal history, which does not show on my version. So I must have, the most recent. Huh?
Does it show on my version, the legal? Because if it says legal, that's the newest one.
No, it doesn't. So I think you might have sent me the one from a year ago instead of the one from
that
was just recently done.
All right. Sorry about that.
That's all right. It'll be an easy fix. We'll get it out to everybody after this.
Okay.
So identifying name, header containing name, date of birth, age, social security number, date of evaluation, interview dates, case number, sources of information, we covered all that, and the identifying data we covered, and the reason for the referral source, was it court ordered or not? What's the purpose of the evaluation? What are the specific questions that the evaluator is being asked to address? A major mistake that you can make in forensic evaluation is to step way outside of the scope of what you're being asked to evaluate. It's amazing. People will sometimes put in their conclusion and their recommendations, they'll address items that the court in no way asked for you to explore. So you want to stick with what the court asks you to do when you get to your summary and conclusion and recommendations.
No, you don't need to go that long. No.
Now, just so you guys are aware, somebody's chattering and I can hear them. So somebody's maybe not muted and having a conversation right now. So you might want to mute yourself. All right, so moving on to the next slide here. Let's see. Oh, actually, still on this slide, summary of significant data. So here, you know, when I used to work for vocational rehabilitation, which is a government agency, and we used to refer people for psychological evaluations all the time as part of the eligibility for a program. And a lot of VR counselors, especially the ones who are really overworked, they'll get an evaluation in the mail and they just skip to the summary. And that's the only part that they read. Is the summary and recommendations, and they skip the whole rest of the report. Well, think of your summary of significant data as being, look, here I need to summarize succinctly the facts that are really pertinent to this case, as well as the questions that are posed by the referral source. So this is a really important section in that sense. You're really weaving it all together. So let me pull up my sample here for that and show you how I addressed the summary. Now keep in mind that the situation with my report, oh, wrong link, here it is. The situation in this summary, I'm trying to kind of give the background for this case as it relates to the two questions that I'm being asked. So Mr. Rhodes reported that he has not yet met his son Brett, who was born on 9/21/12, stating that his ex-girlfriend Hannah Pierce is Brett's mother, and her attorney requested that the judge order the evaluation. He stated that his objective is to obtain co-parenting privileges, but Ms. Pierce has voiced concern about his stability as a parent in terms of alcohol consumption and anger. He explained that he and Ms. Pierce had a very tumultuous and strained relationship for 2.5 years, and they did not part on good terms, i.e. we split up in a bad way and she's pretty bothered by it. I, by the way, like to put direct quotes in my report when I really want to illustrate something. I think it's a good thing to do. Mr. Rhodes, so now I'm going to go into, one of the really relevant areas that's about this concern is his alcohol consumption. So I'm going to summarize the deal with the alcohol consumption here. Mr. Rhodes reported a pattern of alcohol consumption beginning at 15 years of age and persisting until approximately 1 week prior to his evaluation, with the exception of a 3-year period from 25 to 28 years of age and a 4 to 5 month period from April through July of 2012, during which he abstained from alcohol consumption. He acknowledged that he began abusing alcohol during the course of his relationship with his ex-girlfriend, Miss Hannah Pierce, the mother of his child. He reported that he lived with Miss Pierce from June of 2011 through January 2012 and began abusing alcohol to cope with their conflicted relationship. He acknowledged that he would sometimes lose control over his anger when under the influence and would yell and argue with Miss Pierce, contributing to their separation in January of 2012. His drinking increased during a 3 to 4 month period of separation from her, January 2012 through March or April 2012, when he was, in quotes, was really crushed. I was battling a lot of personal demons, fighting alcoholism. That is a very pertinent quote, obviously, when you look at the questions that I'm being asked to answer. So I thought it was meaningful to put direct quotations in there. He reported that he was drinking approximately 6 to 12 servings per day throughout that period. Miss Pierce then told him she was pregnant. They mutually decided to try and restore their relationship, and he abstained from alcohol for 4 to 5 months. However, they continued to struggle with intense conflict, so they broke up again in August 2012, at which time he resumed drinking at reportedly moderate levels. Although Mr. Rhodes reports that his alcohol consumption has been moderate and responsible since that date, so in other words, he's basically saying, okay, fine, I admit that I was abusing alcohol during our relationship, but not anymore, I'm good now, so I should be able to have full parenting privileges. That's sort of the case that he's making. However, I have a lot of question as to the validity of his self-report. And so I went ahead and in the summary of significant data, I outlined the facts that suggest that he's not being forthright about his drinking status. And I like to use numbers and bullet points when it makes sense to do it. So the first fact was his report on 9/19/13 that he last consumed alcohol on 9/12/13 was contradicted by his urinalysis results and the report of his fiancée. So later on in the report, you'll see that I provide information about his drug test results and a collateral interview with his fiancée, and there's a direct contradiction between when he says he last drank and when they say he last drank. Number 2 is account of the extent of his level of physical aggression on the night of his arrest for simple battery and domestic battery on 5/19/10 was contradicted by the account he offered during his assessment at Working Men Battery Intervention Program. That's another collateral source that I had mentioned. So here, in other words, without me going into reading you every one of these lines, I am summarizing the really important things that I gathered from the data that I collected. And I'm painting a picture that this guy's self-report regarding his alcohol status is at least questionable, but is strongly contradicted by the evidence available. And I had pulled his medical records, and his doctor had documented, an ulcer and that the client was advised to stop drinking so the ulcer could heal, yet he continued to drink anyway. And yet he's saying, yeah, but I don't have any problems. Besides, when I had a relationship with this nutty woman here, and that made me drink during this period of time, but other than that, I don't have any problems with alcohol. And so the evidence I'm collecting is certainly contradicting that idea. And I'm bullet pointing that evidence in this section. So then, because one of my conclusions that you get to at the end of the report is that the guy does have an alcohol use disorder, I specifically detail the symptoms of an alcohol use disorder that have been proven in the course of the evaluation. And I lay out, I think, 4 different DSM symptoms of an alcohol use disorder, and specifically how he met those symptoms. And then when informed of the evaluator's findings and treatment recommendations, Mr. Rhodes stated, I know I can be real defensive, adding that although I don't think I really need it, he would participate in the recommended treatment in order to further his goal of being awarded joint custody of his son. So I'm documenting his response to my conclusions and treatment recommendation. So that's my summary of significant data. If somebody took a look at this report and they could only read one section and that was all that they could read, I think this would be probably the most important section where they're getting the bulk of the relevant information about this case. So any questions about the summary of significant data before I move into the psychosocial stuff? All right, not hearing anything, so we will move along. So psychosocial self-report. Now, I really like that the NBFE uses the verbiage self-report in the heading for this section, because that's exactly what it is. We don't necessarily know that all these things are true. This is what the client is reporting to us as far as their background and history goes that would help you to really thoroughly assess the individual. So I talk about where he was born and raised, and I talk about his mother's health during pregnancy with him, and whether there were any birth complications or not, and whether there were any developmental delays during childhood. I talk about how he describes his childhood and how he describes his family system of origin, how he describes his relationship with biological parents and their relationship with each other, and their relationship status. And in this case, there are step-parents involved, so I talk about his relationship with them as well, and his relationships with his siblings. And then whether or not he had any history of child abuse, neglect, or trauma, I address in this section as well. So any questions about family developmental history under psychosocial self-report? Nope. Okay, moving along. Academic history, I like to ask questions like, what was school like for you growing up? What were your grades like? How far did you go in school? Did you do any training after, high school? Any vocational trade training? Any college experience? Sometimes I'll even ask questions like your favorite and least favorite subjects and things. Those aren't things I'm probably necessarily going to put into this report, but it's not a whole lot of information that I offer under this on the actual final report. Financial history and status. He said, I don't have any history of bankruptcy, but he does have some outstanding debt. He reports that he lives on a tight budget, but he's not struggling with his bills or other expenses. Employment history, I talk about what I actually take a very comprehensive employment history. I ask clients to detail every job that they've ever worked at pretty much. Now, not necessarily that I'm going to provide that kind of detail in the final report, but I collect it because I'm looking for things like, gee, you know, they seem to have had like 50 jobs and they never spend more than, you know, a very brief period of time at each job. Why are they leaving all these jobs? Because this is information that might be very helpful and when it comes to even looking for evidence of a mental disorder or personality disorder, those sorts of things. But I detail, so I even look for things like, are there gaps in the employment history, and if so, why? And was he ever terminated, and if so, why? In this case, he was terminated, and he said the reason was because he had too many absences connected with his child custody case, and that he was laid off from another job because the company filed for bankruptcy, and that he's currently self-employed and working as an auto repair technician. No military service history. The substance use history, it's extensive on this report because that was one of the major interests of the court was the guy's substance abuse status. So I provided a much more in-depth description here than what you might see in some other evaluations where that's really not a significant factor in the report. But let me tell you what I would recommend when you're doing a substance use history. I recommend that you look at every single category of substances as they appear in the DSM. So your stimulants and depressants, alcohol, prescription medications, opiates and amphetamines and cocaine and even some of the newer substances like synthetic marijuana, K2 or spice, bath salts, all that stuff, inhalants. And with each of those category of substances, you find out when did the person first use it, when did they most recently use it, what did their pattern of use look like over time, frequency and quantity consumed, and then any symptoms of a substance use disorder connected with their use. All that stuff is relevant. So I'm rather than read you all that information, you can look at it later. Obviously, this case, it was a major focus, was his drinking. Going on to the medical psychiatric history. Now, I think you might see in the newest oral exam study guide that medical and psychiatric history might even be in two different sections.
Yes, we're doing medical separately, and then the next heading will be psychiatric.
Okay, so keep that in mind. What you're going to see on my sample report here is sort of combining those two sections instead of having them separate, but you'll want to do them separately because you'll want to stick 100% with the headings that you were given in the most recent study guide. So he denied any current biomedical conditions, described his overall health as good. He did acknowledge a history of ulcers about 2 years ago that were successfully treated, so I look at any significant medical conditions in the past. I ask about health insurance and access to health care. I also ask when people had their most recent exam and if they have a primary care physician or not. I ask, of course, about current prescriptions. It would be a good idea to ask about past prescriptions as well, just to be thorough. Some of that might become relevant. I ask about any history of significant procedures or surgeries. And then I went into the psychiatric treatment history. He did participate in weekly anger management sessions over a span of 26 weeks at 29 years of age. This treatment was court-ordered, incidental to a simple battery charge. When asked what the treatment was like for him, he stated he did not initially like it. So I asked people, what did you like about the treatment and what did you not like about it? And of course, did they successfully complete it or not? And what did they remember from that treatment experience? What did they get of value from it, if anything? He said he learned a lot about non-physical abuse, and that he didn't care for some of the people who attended that were fairly negative. He denied any other treatment history, including any history of diagnosis or treatment for mental health or substance use disorder. Now, I did include a legal history. And on the most recent oral exam study guide, you'll see a section for legal history as well, from what I've been hearing you guys say today.
Correct.
So here I even talked about what did the guy write, because I give them a packet where they fill in a lot of information about their past, and then I review things in my oral interview with them. And in that clinical interview, I'm also looking for discrepancies between what they're telling me in the room and what they wrote down in their packet. In his packet, he only reported one arrest. It was for a bounce check at 18 years of age. But then when he's in the room with me, he talks about all kinds of other charges. So it's really interesting. Initially, he was, the earlier on, the more that he met with me, the more he began to disclose. So this also highlights the initial defensiveness and underreporting that was going on in this case, and that it took time and work to get him to begin to disclose more of the picture. That's really relevant in this particular case because there's a positive impression management issue here, like there is for many substance abuse evals. Okay, so now it's also interesting the way he described to me that past simple battery charge. He said that he pushed a door open and his girlfriend's friend happened to be behind it, causing her to be knocked down by the door. But when I looked at my collateral records, I found his report of what happened in his psychosocial assessment from the batterers intervention program that he attended years prior. And in that report, he admitted that he physically pushed his girlfriend to the ground and that he physically pushed his girlfriend's friend to the ground, resulting in 2 charges, one for simple battery for the friend and one for domestic battery for his girlfriend. That's very different than, when I was opening the door happened to brush upon the friend, so he's minimizing things even during the clinical interview, obviously. Marital and family life. So I look at past marriages, I look at current relationship status, what happened to past relationships, how did they terminate and that sort of thing. Children, and in this case, even he mentioned that he is living with his fiancée who has 2 children from a previous marriage. They reside together as a family. He has one biological child, Brett, who's now 1 year old and resides with his mother. That's the whole point of this custody eval, or not custody eval, but custody case. He's never seen a son. And he is acknowledging a substantial history of relationship problems. That all his exes have been mostly crazy. Social history. Here we talk about his friends. And does he feel close to them or not? Are they local or do they live on the other side of the country? How does he get along with people? In this case, I always ask when substance abuse is on the table, what percentage of friends drink or use drugs? And what percentage and would they be supportive of him if he chose to stop drinking? In his spare time, what does he do? So I include recreational and hobby information in here as well. It's amazing. Sometimes I'll ask people what they do in their spare time, and the answer is nothing. They don't really do anything. Diet and exercise. I don't believe that that this is a specific section in the new headings, but I added it because I always add it to my reports. And I remember during the oral exam that the feedback I got was that somebody on the panel was glad that I added this section. So just a little FYI there.
I'm sure Howard said that. Yes.
Okay.
I'm sure Harold said he loved it. We do.
Okay. Gotcha. Okay.
We are adding one other. The last one is vocational history.
Okay. And you notice I did have a vocational history on this report. That is an important one, I think, to have on the report. Absolutely.
Is it previously or is it here?
It's here. It's on this report. I mean, I don't know if it's in the most recent study guide because I don't have it apparently.
Okay.
But hopefully it is. It'll
be in the most recent study guide as of today.
Good. I had it on here as employment history. Vocational history is even better verbiage, I think,
okay,
than employment history, but yeah. Okay, so going down here, legal history. And again, oh, we already talked about legal history. So let me go back down. Psychological and social stressors. Now remember, this is a positive impression management guy. So he's faking good, is what I end up concluding. And so he says, no stress except this case. Other than that, everything's perfect in my life. Now let me look here. I do see that we got a question raised. How many visits did you have to complete your clinical interview? Question from Virginia. So let me go up here. I answered that question at the beginning of my report. And specifically, you will see where it says clinical interview with Mr. Rhodes 5 hours. So I guess I didn't say exactly what dates those 5 hours were, but they were not all in one sitting. But I did at least account for how much time I spent face-to-face with him. Might have been a good idea for me to... No, actually I did include that in a different place, interview dates. So it was 2 different sittings, a total of 5 hours on 9/19 and 9/24. All right, so back to, where did we leave off here? We were at collateral contacts. So here I'm detailing my 2 things, the interviews, the collateral interviews that I had, and also the reports, the records that I reviewed. So first I had some treatment records, and I gave the span of those dates of those treatment records from a batterer's intervention program from his previous arrest. And I outlined what I thought was relevant from these records. Was first that it corroborated his report of successful completion and the length of treatment and the focus of the treatment. However, I found contradictions from these records in his self-report about that previous arrest, so I thought that was important to note. I downloaded information about his arrest history from Pinellas County Sheriff's Office. I got records from his primary care physician, and the only thing that was relevant to me from those records was is that he did have alcohol-related ulcers, and it was recommended that he abstain from alcohol. That's really important, obviously, for purposes of this case. The next collateral was an interview with his fiancée, and again, she contradicted his self-report. At first, she was vague in her responses. I think she might have been nervous, like as though she might provide data that would not work to his benefit or something. But she admitted that he had been recently drinking, whereas he denied recently drinking, so that was important. And then I interviewed, and I believe this was a phone interview actually, the therapist that treated him at the Batterer's Intervention Program. She acknowledged that her memory was fuzzy, but she was able, there were some things that she could remember well, and that he was active and participant, but that he seemed to minimize the severity of his anger. Again, direct quotes. And that he admitted in the course of his treatment that he'd been drinking alcohol on the night that he was arrested for simple battery and domestic battery, and that his drinking probably contributed to the anger that night, whereas he denied alcohol being involved in that arrest during the interview with me. So this section, I called it test results on this report, but again, you'll want to use the heading, what was it, psychological or personality assessment. That's what it is. Personality assessment is the heading that you should be using instead of what I did. This is an important note. In fact, the truth is that this note was not in the version of this report that I sent to the oral exam panel. I added it to my sample based on feedback that I got during my oral exam. The question was asked, where did you conduct your testing? What was the environment like? I didn't mention that anywhere in my report, I don't think, so I added this later. I described the urinalysis testing here. I described the profile from the SASE-3, the profile from the Maryland Addiction Questionnaire. the DSM-5 Level 1 Cross-Cutting Symptom Measure, which is just a screening tool. That's all it is. Notice I define each tool that I use and what it's designed to do in the first sentence. So for example, the Symptoms Checklist 90 Revised is a brief self-administered questionnaire designed to evaluate a broad range of psychological problems and symptoms of psychopathology by prompting a client to rate the level of distress experienced by 90 different symptoms over the 7-day period preceding the administration of the questionnaire, resulting in statistical placement on several clinical scales. And then I say what those clinical skills are in relation to the general adult population. He denied any level of distress associated with any of the 90 symptoms on his questionnaire, placing him in an abnormally low position on all of the clinical scales in comparison to the general adult population. This finding is notable given that even very healthy adults with no diagnosable mental disorder have a tendency to endorse at least some level of distress on this test. This guy denied having anything at all. I don't ever have headaches. I don't ever feel down. I'm not ever worried about stuff. So he's saying he's perfect, pretty much. Same thing on the PAI. In fact, all of these tests showed that he was involved in positive impression management, every test that I administered. And I always do a mental status exam. It's just, or I always do the MMSE when I'm evaluating someone, just as a way of objectively sort of backing up my mental status exam later on. But that's just me. You know, a lot of people don't do that. Speaking of which, mental status exams. So I think I mentioned to you, this is often butchered apparently in the reports that go off to the oral panel. I talk about punctuality. I talk about their attire and their grooming and hygiene, the attitude of the individual, indicators of psychomotor agitation or retardation, eye contact and posture, speech, mood and affect, and whether or not mood and affect were congruent. Are they alert and oriented? Don't say alert and oriented times 4. Remember, these are not clinicians, so say alert and oriented to time, place, person, and situation. Specifically, comment on both recent and remote memory. Suicidal or homicidal ideation, indicators of hallucinations, delusions, perceptual disturbances, or other psychotic symptomatology, thought content and process, level of insight, and level of judgment. And if you're going to say and when you talk about insight and judgment, add the evidence of that. So I say his level of insight is poor, as evidenced by a defensive posture in his responses, incongruities in his self-report, and his stated position that he's no concerns about his drinking, despite acknowledgement of several negative consequences associated with his alcohol consumption. I mean, for example, I've never had any concerns about my drinking, and I kept drinking even though I had ulcers, and it contributed to an arrest, and so on and so forth. His judgment is poor, as evidenced by his continued alcohol consumption despite his fiance's concerns and an acknowledged history of alcohol consumption exacerbating relationship distress with his girlfriend. So he acknowledges my drinking has historically got in the way of a relationship. Here I am again drinking in my relationship even though my current fiance is concerned. His level of motivation for treatment is questionable. Because, although he reported a high level of motivation to complete the eval, in order to comply with the court order, he stated he doesn't think he needs treatment. Now, by the way, a little side note, the follow-up to this case, the guy started treatment. Actually, surprisingly, the judge did not order treatment. The judge said, I'm not going to require treatment. I'm going to recommend that you go. It's the best thing to do for you and your kid. The guy showed up to one treatment appointment and never returned. And the attorney of the mother was shocked that the judge didn't order treatment in this case. Just shocked about it. It was amazing. Anyway, the diagnostic impression, at the time that I submitted this, we were still using DSM-4 in our reports. But correct me if I'm wrong, but right now, Norm, the board has transitioned to DSM-5 or no? You'll need to unmute yourself probably to answer this question. Has Have we transitioned to DSM-5, or are we still using
Yes.
DSM?
Yes.
We did. Okay,
DSM-5.
great.
DSM-5, absolutely.
Alrighty. So you will no longer have these 5 axes listed in your diagnostic impression. And then the summary. So in the summary, I'm going to give my sort of bottom line. This is a summary of the facts that I obtained. He moved in with his ex-girlfriend and mother of his child in June 2011. He struggled with a tense and conflicted relationship. He began abusing alcohol to self-medicate against emotional distress, and his behavior while under the influence of alcohol further exacerbated his relationship problems, contributing to separation from Ms. Pierce in January 2012. During a 3-month period of separation, his abuse of alcohol intensified in an attempt to self-medicate with the emotional distress associated with the separation, reportedly reaching an apex of 6 to 12 servings per day. He abstained from alcohol in order to reconcile with Ms. Pierce, but was unable to resolve the relationship distress. He resumed his alcohol use after his relationship with Ms. Pierce was terminated in August 2012. He has historically relied on alcohol as a form of self-medication when experiencing emotional distress associated with relationships. However, the coping strategy is self-defeating, exacerbating his distress. So I'm concluding then that he meets...
Let's go back to summary, because this is where everybody confuses summary and conclusion.
All right.
If you notice, in Aaron's summary, even though he didn't say perhaps, it seems, it's likely, he's inferring that from everything he knows about this particular client, he's making a judgment. It's not the final concluding remark, it's a judgmental remark. And so this is the only place in the evaluation that you may use the words such as it appears, it seems, perhaps, because these are like, you know, because of his early this and that, it looks like this is what caused his problem. So you're not really making, you're just summarizing a dynamic formulation, which we used to do in the 50s and 60s, if you're old enough.
Yeah.
And I heard a little laugh, someone laughed, probably remembers back then. It's just a basic psychodynamic statement about your feeling about this case, what you really think is going on and why he's there. And that's quite different than what Aaron's going to talk about the conclusion.
Yeah. And you know, interestingly, and maybe this isn't the way the panel looks at it now, but originally in my first sample, when I issued my summary, I used verbiage that was a little bit more loosey-goosey, like, you know, it appears and likely and those sorts of things. And I was actually encouraged to be a little bit stronger in my verbiage in the summary. But that's not necessarily the case, right? We can't actually...
No, this is the place I don't know who said that to you, but it doesn't matter. A summary is basically a judgmental statement.
Okay.
All right. It's based on everything you know about this case. You're leading now to everything your judgment is leading to a tight conclusion because of your feelings about the case.
Yes. Okay. So then, the summary should flow seamlessly into the conclusion, which should flow seamlessly into your recommendations, in the sense that whatever I say in my summary connects to everything I say in the conclusion, and you don't see it in the conclusion unless it connects to something in the summary. Does that make sense? Yes. You shouldn't surprise them with something entirely new in the conclusion that wasn't involved in the summary.
Yeah, one of the things Val gets bothered by is if there's no mention of a personality disorder, or just because someone said he had poor insight or something, or no mention of bipolar, all of a sudden we see a diagnosis of bipolar, and it comes out of nowhere. So make sure, like Aaron just said, it's seamless. Everything is smoothly transitioned.
Yeah. All right. So my conclusion, Mr. Rhodes meets diagnostic criteria for an alcohol use disorder. Notice I'm directly answering one of the 2 questions I was asked with that verbiage.
Perfect.
Both of moderate severity. He has a clearly established pattern of difficulty managing his anger while under the influence of alcohol, contributing to interpersonal stress and conflict. It is unclear whether his difficulty managing anger is attributable solely to his alcohol use disorder rather than a co-occurring mental health disorder. Given his defensive response style and invalidation of test results, it is possible that one or more co-occurring mental health disorders, if present, were not detected in the course of this evaluation. So I'm saying, you know, even though I don't have enough evidence to diagnose a mental health disorder, it could be. But because the information I'm acting on is distorted, unfortunately. Okay, so let's see. I'm getting a message that says your audio connection has been lost. Are you all still able to hear me and see me? Anybody out there?
I see your mouth moving, but I don't hear anything. We don't hear you, Aaron. Oh, you're on mute, Aaron.
Okay, I'm unmuted now. There we go.
Okay, we got it.
Yeah, here's what
What was
happened.
that?
We just had a power pull, so you might have seen my light flickered.
Oh, okay, that was it.
We've had some weird weather out here today, so we probably lost power for just a split second, just enough to reset a couple things. Let me make sure that I'm still recording. Before I go any further, I'm going to go to that button. Yep, I'm still being recorded, so that's good. All right. Now I do see somebody has launched a question, so let me go to that real quick. Lost you. Okay, we took care of that, so we should be set now. All right, so where was I? Given that Mr. Rhodes is not yet in remission from his alcohol use disorder, it is this examiner's best clinical judgment, and that's a key phrase, best clinical judgment, that he is in need of psychotherapeutic intervention to aid him in achieving and maintaining remission status with a secondary objective of ongoing assessment for the possibility of a co-occurring mental health disorder. Without such intervention, he is at risk of repeated problems managing his anger while under the influence of alcohol, posing a risk to himself and others. So, given my conclusions, it makes sense that I'm going to recommend these 4 things, because all these recommendations should seamlessly connect to the items in my conclusion. Mr. Rhodes should be referred for outpatient substance abuse treatment focused on relapse prevention skills, alternative coping skills for aversive emotional states, because remember, he's relief drinking, smoking cessation, which I throw in because the guy does have a tobacco use disorder, even though it's probably not relevant to the case, and ongoing assessment for the possibility of a co-occurring mental health disorder. Number 2, he should maintain abstinence from alcohol and illicit substances while participating in treatment, as evidenced by his participation in random unannounced urinalysis drug tests. Number 3, he should comply with aftercare recommendations offered by his treatment provider upon completion of his initial phase of treatment. I added that based on feedback from Harold, actually. And then number 4, to ensure continuity of care, this report should be shared with any mental health or substance abuse professional who works with him. I always tack that on to my report because one of my pet peeves is that people go to mandated treatment with a treatment provider and that provider doesn't have the evaluation, and then the client just blows smoke and doesn't tell them what's really going on, which defeats the whole point of the person being in treatment. And that just ticks me off when that happens. So I make sure that I put that in here with the hope that this will ensure that the treatment provider reviews this information and knows what's really going on. I always tack that on anytime that I'm recommending treatment. Somebody just issued a question. I have never, actually let me expand this a little bit so I can see it better. This is from L.K. Howard. I have never written a forensic report, but I have gone to court as an expert witness. Can I use this case? Yes, absolutely. You can use whatever case you want to use, as long as you think you'll be able to do a thorough report using all the sections and the recommendations we've given you of what should be in those sections. Oh, and then here's a follow-up. Here's a question from Jack. Did you provide directly to the court any CC, S question mark? So I think that's a direct question from Jack to L.K. Howard. All right, so that's really it. This is
for you, Aaron. Did you?
Oh, I'm sorry. Go ahead.
I just meant, did you send it directly to the courts with carbon copies to attorneys?
This report?
Yeah. Well, theoretically, I'm saying what would you have done?
I should have. In the real case, I did not. I did provide it to the attorney. But this, remember, I was ordered to do this by the court. So I should have sent this directly to the court instead of just sending it to the attorney from my standpoint. But in the true case, I goofed up. Looks like we have another follow-up question. Can you please make available your sample report after the webinar? Yes, I will. You will get the sample report. It is in actually the oral exam study guide.
It isn't anymore. We're not putting them in anymore because we've had so many different updates.
Okay.
Since then, and what we're doing is it'll be part of this recording.
Oh, okay.
But the study guide will only have the headings and information about the headings.
I can still email you guys a PDF of this report.
Yes, yeah.
You know, great. I would suggest for the future that I go back and I revise this sample to be 100% consistent in headings with the newest
That would be incredibly great to do. Yes, thank you.
So I'll do that also. Okay, so let me get back to the slides here because I know we don't have much time left. And I want to see if there was anything that I absolutely needed to get out to you guys. We've really covered everything that you're going to see on these next few slides, but there are a few items about the actual oral interview component of the oral exam that I want to make sure that we tackle. These are the questions you want to be prepared to answer when it comes to the oral exam. So look these over, and the objective would be if the question is applicable to your report, then will you be prepared to answer it if somebody on the panel asks it? Now I can tell you what I was asked. I remember some of these anyway that I was asked. I was asked why I used the SASE 3 instead of some other tools like the MAST. And I explained that the SASE, unlike the MAST, had validity scales, had scales to detect subtle attributes and defensiveness. The MAST is a very subjective tool that's entirely based on the premise that the client is responding accurately and being forthright. So it's flawed in that respect. And that unfortunately it's biased towards a false positive. For example, one item on the MAST, if you've ever attended an AA meeting, you automatically get a score of 5, which is enough to conclude alcoholism. But what if you went to an AA meeting to support a friend or because it was required as a part of your grad school training or something? So there are a lot of flaws, and I was able to talk about that when I was asked that question. And then I remember I was also asked, what else on here was I asked? I can't remember what else I was asked on here. But now you may be asked questions that don't show up on this list, but you definitely need to be prepared to answer the questions on this list if they apply to your case. I remember I was asked a few other questions, but these were the biggies. I was asked more about my urinalysis drug testing procedure, that kind of thing, because that's unique. Now I'd recommend don't pick a complicated case. Pick a simple case. And I actually, honestly, there were a few things that I thought in the real case that would have complicated the oral exam that I just cut out of the entire picture as though they never happened, because I wanted to keep things pretty simple. So it'd be actually easier for me to defend. So you don't want to pick your more complicated cases, I would suggest. That's my recommendation anyway. This is my contact information, so if you do have follow-up questions about today's training or anything that I presented, you can reach me at this email address. But I want to we got just a few minutes here, any questions that you want to make sure that you get answered before we start concluding things here. I'm not hearing anything.
Well,
remember you'll have to unmute yourself if you do want to ask a question.
Yeah, Aaron, you did an incredible job. I am so impressed. Even though you did such a splendid job, I'm sure there's still going to be issues when you submit your samples. Uh, I'll still be available, even though we're not doing the mentorship. You can still send me your first sample just to make sure it's okay. I'm not going to scrutinize it with extreme detail, but I'll overview it to give you a feeling, and there may be some other people in the committee who might do the same thing. But if you have questions, we're always available. Call me, call Aaron, as he's saying. He's been very gracious to allow his information to be there so he can be contacted. There is an update on the mental status, Aaron. We're not going to put, we're going to keep it consistent, so only the very small headings are included. We're not going to use those, the appearance, behavior, conversation. We're just going to keep it simple. And I just sent everybody the updated study guide with those particular headings in the mental status. I think I covered them all. And as Aaron said, and we all say every time we do a training, if there's something positive, which means not good, if there's hallucinations, delusions, remote memory problem, spell it out, how you got that information. Because the mental status, it's not just the mental status, it's your license. Everyone who is licensed should know how to do a mental status. That separates licensed people from unlicensed people. You are permitted by license to do mental status and diagnosis and treat, of course. But make sure if someone has a remote memory problem, how did you find out they have a remote memory problem or recent? You have to have certain things and techniques that you've used to determine that. So then you have to talk about them. And mental status is a very great piece of artwork that you have to learn how to do. Most clinicians that I know of are not taught mental status in school. It's taught by good supervision.
Yeah.
So don't be afraid to ask how to do them, because this is a great specialty item.
One other note about as far as the actual oral interview part of the exam goes. Now, it is going to be via webcam. I think you guys use the GoToMeeting platform for that oral
Correct.
exam. And I want to encourage you, I mean, they're not raking you over the coals maliciously, but they are going to ask you challenging questions. And so go into it with an attitude of, these are colleagues who are going to ask challenging questions, and come into it with an attitude of curiosity and collaboration and some confidence, and if you're prepared to answer those questions, you'll do a great job, and be reasonable. And I think the anxiety attached to it is might be pretty strong for some people, but
Well, right now you have Howard Carroll, who was the chair of the oral committee. You might want to ask him a direct question, because he's the man.
yeah. While he's on, anybody have a question for him?
Yes, I have a question.
All right, Christine.
Does the amount of time taken to formulate an answer have any effect? Because I know in court, you are permitted to take time to formulate, and you don't really spew out an answer immediately.
Sure, that's a good thing to practice, not to knee-jerk and come up with an answer that turns out to be wrong, to give it some thought before you respond. There's no problem with that at all.
Okay, thank you. That helps.
I might mention one other thing, a resource that you might find helpful. It's called The Principles of Forensic Report Writing. It was published in 2013 by 2 forensic psychologists, and there's 2 samples in there, and it's pages, but there's a lot of good current information in there. Principles of Forensic Report Writing. So there's Carson and Nadkarni, Nadkarni.
NADK, what again?
Nadkarni.
Okay, gotcha. All right, great.
Carson with a K. Another, if you're going to use the MMPI, I would suggest you might look at the, it's a 2015 published by the APA, using the MMPI-2 in forensic assessment. Two of the authors are Butcher and Green, who are the gurus of the MMPI-2.
Okay. Well, folks, I know that we are out of time, but if you have some other follow-up questions, feel free to send them. Now, remember, take the evaluation when that screen should pop up in just a moment as soon as we conclude this webinar. But in the worst case scenario, you'll get it in the follow-up email, which I think comes out tomorrow. The system-generated follow-up email anyway. I'll be sending an email. It might not be till early next week, but it'll have a lot of attachments just in case you weren't able to download these attachments, and it'll include my sample report. And I'm actually going to try and revise my sample report first, though, to make the headings 100% consistent with the most recent oral exam study guide. And so it might take me a few days to get to that, but I'll get that out to you pretty quickly here. Anybody want to ask one more question, or do we want to conclude things here?
If you'd all show a raise of hands so we could sort of applaud Aaron for an incredible job. I'd like to see hand raising on everybody to show your appreciation for his incredible work.
Oh, thank you. I appreciate it. One last thing. You probably got an email from me already. If not, I am searching for information on any examples of how some other therapeutic professionals, like psychology associations, for example, have made efforts to try and prevent professional counselors or social workers or marriage and family therapists from doing forensic work, including trying to prevent them from being able to administer tests like the MMPI or PAI, or trying to exclude them from being able to do competency evaluations or providing diagnoses. If you have any information, I know that there have been efforts in different states, please send it to me, because I'm working on a project trying to reach out to professional associations to expand our partnership. And part of what I want to show them is, look, an organization like the MBFE, I mean, this is the only credible national organization that extends forensic certification to counselors and marriage and family therapists and social workers, and not just psychologists. So it's an important resource to try and help create a sense of maybe help expand anyway the legitimacy of some other allied health professionals doing forensic work besides psychologists. And I have a lot of psychologist friends who are very supportive of the work we do and are very inclusive, but there are some who really want to keep us from doing this kind of work. And I need to know if you have any information, past or present, of efforts to try and undermine any of us from being able to do this kind of work, so I can use that information when I'm collaborating with the professional associations. Well, thank you so much, everyone. It has been a pleasure, and we'll go ahead and wrap things up for today. And before long, we'll have recordings available for you. Good luck prepping for the written and oral exams. I hope to see many of you having your names added on to the certification list in the near future. And I hope you have a good weekend. All right. Bye.
Bye-bye.